Well, one my lord, MSc pending matter of the year 2017, my lord. It was last listed on 16/9/25 for order, I mean, my lord.
14th August.
Always.
Your Lordship, I beg to mention item number 1. The conducting counsel, Mr. Arbora, has some personal difficulties, so he is unable to.
Heard Miss, what is your name?
S. Bowa.
Heard Mrs. Borua, the learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant, Mr. Arbora. Considering the grounds, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
May I please, Your Lordship, I beg to mention item number 15 and 16. Here, I am appearing on behalf of MSU Chakravarti, Your Lordship. 15 number item is I am for the appellant, and in 16 I am for the respondent, Your Lordship. Due to some medical exigency, Your Lordship, today the matter may be adjourned and another date may be fixed. And I have taken consent of the other side also, Your Lordship.
You are, what's your name?
M. Chatterjee.
M.
Chatterjee.
Heard Miss M. Chatterjee. Sir, yes.
My Lord, if a closer date may be fixed, it is a 6-7-year-old matter.
Heard Miss M. Chakravarti. Chatterjee, learned counsel appearing on behalf of Miss U. Chakravarti. Learned counsel for the appellant. In one case appellant, another case respondent. Who prays for an adjournment due to medical urgency of the conducting counsel. The prayer is not opposed to by the learned counsel for the other side, hence pray same is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Please, Your Lordship. Lordship, item number Lordship 13 and 14. I'm for the affiliate. Well, the respondent side informed us that his daughter is admitted in hospital, Lordship. So, pending matter will be adjourned for the day, Lordship. It takes after 4 weeks, Lordship. 4 weeks.
Heard Mr.
M. Das.
M. Das, learned counsel for the appellant, who submits that learned counsel for the respondent has informed him that his daughter has some medical urgency. As such, has prayed for an adjournment. The prayer is allowed. Let this matter be listed after 2 weeks.
4 weeks, Lordship.
After 4 weeks on a date to be fixed by registry.
Lordship.
May it please your Lordship, I beg to mention item number 11 of daily list. I have taken the consent from other side.
Lord, I'm for the respondent, Lordship. Can it be fixed a date, Lord?
Heard Miss, what is her name?
D. Devi.
Heard Miss D. Devi, learned counsel for the appellant who seeks an adjournment. Also Mr. M. Das, learned counsel for the respondent who does not oppose the prayer. Let this matter be listed after 4 weeks.
Can it be fixed a date, Lord?
10 November
Then,
or 4 weeks on a date to be fixed by registry.
Lord.
4 weeks.
May it please your Lordship, I beg to mention for listing of a pending make appeal, Lordship. It was last listed a year
August.
ago, Lordship.
14th August.
Highly blessed, Lordship.
May I please, Your Lordship, I beg to mention listing of 2 MFAs in orders for them.
17th August.
Lordship, praying for listing the matter for orders on Monday.
14th August. 14th August. 28th August.
Lordship, and next week, any date.
5th of August. 5th August.
May I please, Your Lordship, prayer for listing, my lord. The matter was last posting on 29/2023, my lord.
Yes, Putul. 14th of August.
Please, Lordship, I beg to mention one MSc appeal for releasing of 50% number 20.
14th of August.
May it please your Lordship, I beg to mention item number 18, 25 and 26. In item number 18 and 26, we are the appellant, and in 25, we are the respondent. We have taken consent from the other side. Lordship may kindly adjourn the matter for 3 weeks.
Heard Miss
25 also. My lord, relating to 25, I have objection.
Okay.
So many occasions they've taken time and without any information, it is not fair.
Was 18 and
18, 25 and 26.
18 and 26.
25.
Ms. D. Goswami, learned counsel for the appellant, prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed learned counsel for the other side who does not have any objection to the same. Hence, prayer is allowed. Let this matter be listed after 2 weeks. 25, we will take up the matter when the matter is called. You remain present.
Lordship.
Lordship, in 25, I am there. I was informed as bereavement of Mr. Argosami, he is not coming to court. That is.
And I am
I'm
for the
the appellant.
claimant respondent, my lord.
Appellant, I am appellant.
Okay, let the matter be called. We'll consider the adjournment prayer at that time.
Lordship. Obliged, Lordship.
May I please your lordship, here I'm appearing on behalf of the appellant in item number 2 as well as in item number 3. So both the matters notice have been served and matter may be fixed for hearing, your lordship.
Heard Miss M. Chatterjee, learned counsel for the appellant. Also heard Miss
You be having, Lordship.
U. Bihani, learned counsel for respondent number. Respondent for which respondent? You are also appearing.
Sole responding, your
All
lordship.
respondent. This appeal is ready for hearing. Hence, list the same for hearing. Date of 10th of November.
Date may be given, my lord, it's 11 matter.
It is not possible. 10th of November.
Obliged.
Matt, please, lordship.
Yes.
There were two appeals. And after the disposal of the appeal, the appellant has also filed a review application in both the cases. And on behalf of the my lord, collector, also there is a review application in both the cases. And as I indicated on the last occasion, my lord, the review application filed by the appellant is dependent on the failure of the review application filed by the collector. That's why I submitted my, and possibly they will also accept that if my review application is dismissed, then their appeal review may be heard and it may be decided, and half of the case will be won by them by that way. And if my review application is allowed, then their review application will be left with no merit. This is the position.
So we'll take up your review application.
My lord, my lord.
Which one is that?
There are two reviews. One is review petition number 292 of 25, and the other one is 293 of 25.
290. 292 and 293. The 285. 292 and 293.
And in both the cases, my lord, issue is same.
There are only two review applications.
Yes, my lord. Filed by the collector. One is 292.
Item number
the other one is
7.
293.
Item number 7. Item number 7.
Fine.
293. We are taking up 292 first.
Yes.
One is item number 5 and another is item number
Yes, yes. So we are taking up item number
5.
5, review petition 292.
290.
Hmm. My lord, may kindly take up 293, same, my lord, I've just decided to argue on the basis of 293.
Just a minute.
My lord, may this lordship's judgment starts from page 37.
What is the ground for review?
My lord, I'm coming to that. I just give the background first, my then I'll make my submissions. Lordship, in this case, what happened? The award was passed by the collector, and thereafter there was a reference. And in the reference, my lord, there was enhancement of the award, and primarily, sorry if I do this. Primarily, the value of the land. Based on a sale permission, my lord, the value of the land per bigha was enhanced to 3 lakh per bigha, my lord. Now, I'll not take your lordship to the various aspects of the award and the judgment and order passed by the reference court. Lordship's judgment starts from page 37, as your lordship has seen. Lordship had framed certain issues which your lordship will find at page 56 in paragraph 45. And review also I am seeking on a limited point and in respect to a particular issue. Manner. Page 56, if your lordship has got manner,
Yes.
at the bottom, lordship will find paragraph 45. It reads like this manner. In this appeal, the following points may be formulated for determination. This was framed by this honorable court, my lord. Number 1 was whether the reference court was correct in assessing the market value of the acquired land at the rate of 3 lakh per bigha. Number 2 is whether the reference court was right in assessing the compensation amount for the severed land of 1 bigha 17 leches at the rate of 1/3 value of the rate at which the acquired land was assessed. C is whether the reference court was correct in awarding Jirat compensation of rupees 67,62,820 only to the appellants. And number D is whether the reference court was correct in deducting the Jirat value which was already paid to the appellants from the enhanced value of the acquired land assessed by it while paying compensation for land acquired by the respondent number 1. Now, so far as, my lord, the point number A, B, C are concerned, all these were decided against the appellant. I am just showing, my lord, the discussion on first point, that is A, starts from paragraph 46 at page 57, my lord. Lordship will find it paragraph 46. Let us discuss the first point.
Yes.
Now, this ends in page 66, my lord. Page 66, just above the paragraph 53, lordship will find. Just above paragraph 53, my lord.
Yes.
Just the line, the last sentence, the aforementioned first point for determination is accordingly decided in affirmative against the appellant. Now, the second point starts from paragraph 53, my lord. As regards the second point. Now, second point, decision is at page 67, my lord. Next page, what you will find. In this paragraph itself, towards the end at page 67, the last sentence, my lord. This court, therefore, is not inclined to interfere in the valuation of the severed land assessed by the reference court. So, this point was also decided against the appellant. Now comes the third point. It starts straightway from paragraph 54. Now, let us discuss the third point. This point, my lord, starts from paragraph 54 and ends in page 69. Page 69, my lord, just above paragraph 58. Your lordship has got me.
Yes.
Just above paragraph 58. It says, hence, the plea that Jirat compensation should be assessed at the rate per bigha system is not an acceptable plea and does not merit consideration. This point for determination is accordingly decided against the appellant. So 3 points were decided against the appellant. I am not concerned with that, my lord. The final point was, my lord, I am just coming back again to para 45 at page 57. Page 57, I am just reading that point again, my lord.
Yes.
It reads like this, my lord. Whether the reference court was correct in deducting the Jirat value, which was already paid to the appellants from the enhanced value of the acquired land assessed by it while paying compensation for land acquired by respondent number 1. Let me read that finding, my lord, then I'll make my submission, my lord. The finding starts from page 69, para 58.
Yes.
As regards the fourth and final point for determination, there is as to whether the reference court was correct in deducting the Jirat value which was already paid to the appellants from the enhanced value of the acquired land assessed by it while paying compensation for land acquired by respondent number 1. It appears that the reference court, while assessing the value of the acquired land, observed that the sale value of the land would naturally include value of all standing trees, shade trees, unless the evidence is led to show that acquired land is a vacant plot of land, and therefore the reference court, though increased the valuation of acquired land to rupees 3 lakh per bigha from rupees 1 lakh per bigha. However, it directed that no additional amount for standing bushes, shade trees, structures, etc. would be payable to the appellants as Jirat compensation. Therefore, the amount of Jirat compensation of rupees 67,62,820 only, which was already paid to the appellants, was directed to be deducted from the total compensation assessed against the market value of the acquired land. This court is unable to persuade itself with reasoning of the reference court in deducting the already paid compensation against Jirat component from the market value of the land assessed by respondent number 1. Section 23 of the Land Acquisition Act 1894 provides as follows. Matters to be considered in determining compensation. In determining the amount of compensation to be awarded for land acquired under this act, the court shall take into consideration first, now Lordship will kindly note this, first it says the market value of the land at the date of publication of the notification under section 4, subsection 1. And secondly, damage sustained by the person interested by reason of the taking of any standing crops, trees, which may be on the land at the time of collectors taking possession thereof. We are concerned with these two, my lord, provisions, first and secondly. Now, rest we can skip, my lord. Then, page 72, para 60, the further discussion, my lord.
Yes.
On perusal of the aforesaid provision, it appears that as per section 23(1) of Land Acquisition Act 1894, the heads of compensation against market value of land and damage to Jirat are shown separately under first and secondly, respectively, of section 23(1) of the Land Acquisition Act 1894, which leaves no ambiguity regarding the fact that loss suffered due to
Loss.
component of Jirat, it should be loss possibly.
It should be loss.
Suffered due to component of Jirat must be assessed separately from the market value of the land itself. Hence, the compensation assessed against the damage caused to Jirat cannot be deducted from the compensation assessed against the market value of the land at the date of notification under section 4 of the Act. Therefore, the impugned judgment and award of the reference court to the extent of it deducting the Jirat compensation of 67 lakhs 62,820 only already paid to the applicant from the total compensation for the acquired land at the market value of rupees 3 lakh per bigha is found to be contrary to the statutory provision and accordingly hereby set aside to their extent. The appellants are therefore entitled to the amount which was deducted as Jirat compensation from the total compensation against the market value of the acquired land pursuant to the impugned judgment and order along with the interest thereon at the rates prescribed by the Land Acquisition Act 1894. In view of the above discussions and reasons, the instant appeal is partly allowed to the extent as indicated in the foregoing paragraphs. Well, I have filed the application for review, seeking a review of the order, particularly the decision on this final point, my lord, that is B, on the ground that my lord, a reading of the judgment of the reference court in this regard, particularly on this point, will show that this 3 lakh per bigha, which was found to be the market value of the land, my lord, per bigha, actually included the value of Jirat also. And there was a, my lord, detailed discussion on that, which your lordship will find. In the reference court's order, my lord. Well, the order, the reference court's order starts from page 11. And the discussion on this point, lordship will find. Well, I'll read from para 16 of the reference court order at page 24, my lord. Page 24, my lord.
Yes.
No other sale lead has been adduced in evidence. However, the claimant has relied on Exhibit 44, which is a communication from Joint Secretary to the Government of Assam Revenue and DM Department addressed to the Deputy Commissioner, Dibrugarh, granting approval for sale of a plot of land be hitting T estate, claimant's estate, at a valuation of rupees 3 lakh per bigha. The said letter is reproduced below. Now, lordship will find the body of the letter says, in inviting a reference to the letters on the subject cited above, I am directed to convey the approval of government in Revenue and Disaster Management Department of a permission for sale of TP land, that is tea plantation land of Bihiting Tea Estate measuring 23 bighas, 3 katha, 4 lechas covered by dag number so and so and so and so under grant number so and so as per position dated 12/10/2006, subject to clearance of all necessary dues to the government and payment of admissible stamp duty and registration fee on the treasury stroke sale deed as per valuation fixed at rupees so and so by the deputy commissioner. The transfer sale permission will not affect the interest of the tenants, if any, over the plot of land proposed for sale. The sale permission is accorded as per special case following the views offered by Advocate General Assam in so and so and adhering to the Honorable High Court's order in so and so. The said letter has been approved by PW4 C so and so, Junior Assistant, Office of the Deputy Commissioner, Dibrugarh, which is not disputed by respondent. Rather, from the cross-examination of PW5, it appears that the government respondent has accepted the aforesaid valuation as correct, while disputing the claimant's valuation of 6 lakhs per bigha. PW5 further deposed that Exhibit 45 is a letter issued by the Additional Deputy Commissioner, Dibrugarh Revenue Branch, to the Deputy Secretary, Government of Assam, Revenue Settlement Department. In the writ petition number so and so, originally the land value was wrongly put, which he corrected by that letter fixing the land value at rupees 3 lakh per bigha. Similarly, Exhibit 46 is a letter issued by the then Deputy Commissioner to the Deputy Secretary to the Government of Assam, Revenue Settlement Department, wherein the value of the land of so and so grant under so and so moja was fixed as to be 30,000 per bigha, which was found to be wrongly typed. Therefore, subsequently said valuation was corrected by Exhibit 45. During cross-examination by the government leader, it was only got confirmed that aforesaid valuation of the land at the rate of 3 lakh per bigha is still standing. In other words, it is indirectly conceded by the state respondent that the value of the said land of rupees 3 lakh per bigha. What transpires from the above is that Deputy Commissioner / Collector Dibrugarh fixed the value of the claimant's land at rupees 3 lakh per bigha at a time contemporary to the acquisition in respect of the land belonging to the same tea estate for the purpose of sale. It is important to bear in mind that 23 bighas of land was part of the Bihiting tea estate and the valuation of 3 lakh per bigha was made for the purpose of sale, not acquisition. In a process of acquisition, value of the land is determined ignoring the value of the standing trees, structures, etc. thereon, as their valuation for paying jirat compensation is made separately. But when a transaction of sale of part of tea estate land is effected, the sale value thereof would naturally include the value of the standing tea bushes, shade tree, etc., unless the evidence is laid to show that the said plot of land was a vacant, which the claimant has not done. In other words, concerned authority, while determining the value of the tea patta land for the purpose of sale, would take into account the value of the standing bushes, etc. also, in order to arrive at the minimum permissible sale price, below which price sale deed would not be accepted for registration. The object of fixing of such benchmark obviously is to ensure that the state is not deprived of the proper sum receivable as revenue from stamp duty and registration fee that would be required to be paid upon the sale value of the land shown in the sale deed. The vendor certainly would not sell the land by discounting the value of the tea bushes, etc., standing thereon. The reference to stamp duty and registration fee made in Exhibit 44 while accepting the value of 3 lakh per bigha clearly indicates this aspect. Mysteriously, the claimant has not made a whisper as to whether the sale actually took place pursuant to the permission granted by Exhibit 44. If so, the sale deed in respect thereof would have been the best evidence to show whether the land was vacant or land had standing crops, etc. on it, and more importantly, would have indicated the sale price withholding of the same necessarily leads the court to presume that the same, if produced, would be unfavorable to the claimant. The upshot of the above discussion is that, in view of the stand of the official respondent, there is no difficulty in accepting valuation of 3 lakh per bigha in respect of the acquired land, but no additional amount as value of standing trees, shade trees, structures, etc. as jirat compensation would be payable to the claimant. In view of the above finding, the claimant's put forth vis-a-vis enhancement of jirat cannot be accepted. It is noticed from the evidence of the claimant that claimant received compensation of rupees so and so and under protest in respect of the so of the land at the rate of 1 lakh per bigha, but had received jirat compensation of 67 lakhs 62,280 under protest on so only in respect of so of land, and jirat for remaining land of 146 bigha amounted to rupees so was paid to the encroachers. It is averred that after sealing was finalized sometimes in 1970, the claimant was allowed to more than 250 bighas as ancillary vacant land in this tea garden in so and so and so and so and so and so. 5% having residents in contiguous villages falsely entered their names, claiming as tenants against a few bighas of said reserved ancillary land, while the mandal was conducting the field irrigation. Well, these discussions are no longer necessary. So, as your lordship has seen, my lord, it is absolutely clear that the valuation of land given was for the purpose of sale.
Okay, what would be the value of vacant land if Jirat is deducted from there?
My lord,
The assessment of rate of land,
my lord.
the value of land was assessed at the rate of, as per your submission, 3 lakhs, including the Jirat.
Yes.
If
Now,
we exclude Jirats,
yes.
what would be the value?
My lord, that's what the learned reference code did, my lord. Since jirat value is included in this enhancement amount of 3 lakh, the jirat which was already paid to them.
No, that I understand
My
your
lord,
submission.
my lord.
Under 23, you have to assess land separately,
Yes,
Jirat's compensation separately.
correct, my lord.
Suppose we accept your submission,
My lord.
then what would be the value of land? How less it will go from 3 lakhs to?
That is what I'm saying. What in this case, what has happened? Jirat was separately assessed and paid to them once. This is what the judgment says, and they also accept. I'll show from their ground they accept. If the value of the land is held to be 3 lakhs per bigha, then they would end up getting the jirat compensation twice, which your lordship will find they themselves also accept, my lord.
No, that is not my query.
My lord. How do I assess it, my lord?
Yes.
My lord, in this case, my submission will be assessment of jirat, value of jirat separately is not necessary because, my lord, while assessing the value of the land at rupees 3 lakhs per bigha, the reference court has accepted the document of a sale permission which was obtained by them.
No, why am I putting this question?
My lord.
Suppose for a contiguous land, adjacent land, which was sold at the rate of 3 lakhs, including Jirats.
My lord.
Jirats there and Jirats in the acquired land, number of trees, bushes may be different. It has to be assessed separately. Are you getting my point?
My lord, I get that point, but here in this case, my lord, since 3 lakhs, my lord, 3 lakhs in respect of a land, they themselves have shown that it had tea bushes. Here,
Because
full
tea,
amount of
tea bushes have specific rates. Different trees have different rates. Jirat compensation has to be assessed accordingly, according to the rate of particular kind of jirat. So your submission is that no separate assessment under 23 secondly has been made.
Well, my submission is slightly different. What I am saying is, my lord, the value of land at the rate of 3 lakhs per bigha was accepted on the basis of a sale permission, which included tea bushes. which included T bushes. That is the finding of the court. Had it been a sale permission only in respect of a vacant plot of land, and which it did not contain, because that they have also accepted, which you will find in the grounds taken in the appeal. I'm just pointing out one aspect. If your lordship kindly takes the appeal filed by them, I'll just point out my LA appeal number 2 of 2019. If your lordship has got the memo of appeal of 2 of 2019, my lord.
Yes.
Lordship may kindly turn to page 16 of LA appeal 2 of 2019. They have not said that the reference court has committed any error in deducting the amount of jirat after the land value of the market value of the land was assessed at rupees 3 lakhs. They have taken a completely different stand, which your lordship will find at page 16, my lord. Ground number F. May I read it, my lord?
Yes.
For that, the learned court below, while passing the impugned judgment and order, failed to appreciate the fact that concerned record reveals that the landowner appellants were awarded jirat for tea bushes, shade trees, and staff quarters amounting to rupees 67 lakhs 62,820, assessing an area of 83 bighas, 2 kathas, 5 lechas, and on the other hand, paid jirat compensation amounting to rupees 2 crore 92 lakhs 87,116 to the encroachers, assessing an area of 146 bighas, 1 katha, 10 lechas, as in their occupation showing tea bushes, shade tree, fencing, culvert of the landowner appellants as owned by them. Out of the said amount, only 53 lakhs 56,600 was paid to them as value of their structures, which fact substantiate that encroachers were given double jirat compensation. They accept if this is paid, they will get double jirat compensation as compared to the landowners' appellants. But the learned court below, while assessing the impugned judgment and order, overlooked the said aspect of the matter, and as a result of which passed by the impugned order in a mechanical manner, and as such, the impugned judgment and order is liable to be set aside and modified. So they also accept that as far as the encroachers were concerned, they were given some amount which amounts to giving double jirat compensation. So in what they are claiming, my lord, in substance is, my lord, parity, and they also should be paid compensation doubly. And that is my submission. That is the purpose of filing this review application, my lord. If they have already got an amount of compensation in respect of jirat, that has to be deducted from the value of the total compensation, because in the market value of the land per bigha assessed at rupees 3 lakh per bigha, the amount or the compensation for the tea bushes, etc., and other things available there, my lord, in respect of jirat, is also included in this market value of 3 lakh per bigha. And if they say that if you have paid this amount wrongly to those encroachers, we also should be paid because encroachers got double compensation. And my submission will be that even if an authority committed an error in making some assessment, they cannot take advantage of such error so as to get a similar advantage. That is my submission. And in the other case, my lord, the amount only differs, issue is same, my lord. There it will be 85 lakhs and odd, my lord.
No, what is the finding?
Not 290. In the
No, I have some queries.
Right.
The reference court in its judgment assessed the market value of the land acquired at 3 lakhs per bigha
Right.
and made an observation that no separate compensation against Jirat is required to be paid,
Yes.
which is held to be wrong by this court in view of the provision of section 23.
My lord.
So where is the error apparent?
My lord, my submission before your lordship will be error is like this, my lord. The reasoning given by the reference court. A reference court has given a reasoning that see, in the sale permission obtained in respect of a land showing the value of 3 lakh per bigha, there the amount or the value of Jirat is also included. Because when you have taken a sale permission, my lord, lordship is aware, my lord, if it is an immovable property, anything standing thereon
No,
is
but that sale permission does not indicate that
My-
this valuation, that is the observation of the reference court.
my lord.
The sale permission letter gives no indication that it includes the value of Jirat.
My lord, that is
And what is held by this court in the judgment under review is that holding by the reference court that no separate compensation for Jirat has to be paid is a wrong finding in view of the provision of section 23. This court may be right or wrong, but
no, my lord. On merit, I don't say.
but on whether this court can go into that question in review.
My lord, my submission will be if your lordship goes to that finding, my lord, lordship will find the reasoning that has been given by the reference court has not been discussed or, my lord, disturbed by this on the court. There is no discussion on the reasoning given. If your lordship goes to this first point discussion starting from page 57, my lord, lordship will find there the reasoning given by the reference court has not been discussed or found to be illegal. There is no discussion on that matter.
Okay.
Lordship has rightly gone in terms of section 23. Well, in a normal case where the reasoning given by the reference court is not there, reasoning is very simple, my lord. The value of the land when a person goes for sale of a land, that is the reason given by the reference court, my lord. When a person goes for sale of a land, whatever is standing on the land, either it be in the form of a tea plantation or any other structure, since the entire matter is going or being transferred to another person, the government will ask for the value of the entire value that is being transferred. And this value will include any other structure standing on the land or any tea bushes standing on that. And that is how the base value is assessed. But if exhibit 44, my lord, which was the sale permission, was in respect of a land acquisition, then the matter would have been different. Then the question would have been whether it included only the value of the land or the tea bushes standing thereon. Here, when it is a sale permission, the court says that they have not shown anything that it was a vacant land. See, I have given this exhibit 44 relates to a tea plantation land or tea patta land which did not contain any tea bushes. That is not their stand. Even in the appeal, they have not taken that stand because that is not correct position. They cannot say, and that is why they have taken rather contra submission that see, the encroachers were given the compensation twice. So I also should be given compensation twice. They have accepted that. Till now they have not raised the plea that no, that sale permission was in respect of a tea plantation land or tea patta land which did not contain any tea bushes. That is my submission. And this reasoning, somehow, my lord, because the arguments were made in piecemeal on several occasions, somehow, my lord, possibly inadvertently skipped your lordship's notice, my lord. And that point or that reasoning given by the learned reference court has not been, my lord, disturbed by your lordship or found fault with, my lord. That is my submission. And in respect of the other, only amount is different. Man.
Submission is same.
Same. There,
Area of land is different and the amount is different.
and I've got just two submissions, judgments to be cited. Different. If submission, I1. Two judgments are there. I'll just.
You
One
give
is
citation.
citation I'm giving, my lord, and I'll copy. I'll furnish the judgment, copy of the judgment. 2013 8 SCC, page 320. 2013 8 SCC, page 320. Kamlesh Verma versus Mayawati. Para, my lord. This judgment I am relying on for the purpose of power of review, my lord. Para, my lord, 13, I'm sorry, man. Para 13 is also the 13, 14, 16, and 20, my lord, summarized in para 20.
Yes, what it says.
It is mainly on the power of review, my lord. It says, my lord, review of the earlier order cannot, para 14, my lord, review of the earlier order cannot be done unless the court is satisfied that the material error manifest on the face of the order undermines its soundness or results in miscarriage of justice. Then relying on the earlier judgment of Avtar Singh, my lord, a review is not a routine procedure. Here we resolve to be a, you can skip, my lord. Then para 16, my lord. Error contemplated under rule must be such which is apparent on the face of the record and not an error which has to be fished out and searched. It must be an error of inadvertence. The power of review can be exercised for correction of a mistake, but not to substitute a view. The mere possibility of two views on the subject is not a ground for review. The court in so-and-so held so-and-so. So, and at last, in para 20, it has been summarized. So, in our case, as I have submitted, my lord, relying on the judgment I am submitting, that basically, possibly it was due to inadvertence that reasoning given by the reference court was not taken into consideration before deciding the point number 4, that is D. And that is why I'm asking for a review, my lord. And I'm not making any argument to say the view taken by your lordship is wrong. What I am saying is, my lord, the view taken by the reference court was not possibly somehow taken into consideration, and that is very apparent. And the second judgment on which I am relying is because of the nature of ground they have taken in the memo of appeal. Even if they argue, my lord, they say, see, those who were encroachers there, whatever amount was given to them, and subsequently there was no deduction. So similarly, we also should be treated. For that, I am relying on the judgment, my lord, 1995 1 SCC. Page 745. Chandigarh administration and another.
Yes, on which
Versus Jagjit Singh, my lord. Para 8 I am relying, my lord.
On what point?
On the point that even if the earlier an authority made a mistake, you cannot take advantage of that to compel the court to pass another similar erroneous order. This is what they are saying, that you have made an error. The reference court made an error, or sorry, the award was wrongly passed in respect to the encroachers. They got twice, so we should also get twice. On that, my lord.
No. Their submission was,
Madam.
if I remember that,
Madam,
in case of the encroachers, though the acquired area of the acquired land is much lesser than the acquired land of the present appellants, they were paid more compensation against Jirat.
As I have
That
read,
was their submission.
my lord, as I am reading from their memo of appeal, that submission is not, possibly is not relevant in our review application. What is relevant is, my lord, they have taken a ground saying that this in respect of this amount for which I filed the review, that is 67,62,820, they say that the encroachers, which facts substantiate that encroachers were given double Jirat compensation. And this point was not taken into consideration, they are saying by the reference court. This is in ground number F in their memo of appeal of LA appeal number 2 of 2019. And in respect, I deliberately searched what is the point they have taken in respect of this in the appeal, my lord. This is the only ground they have taken in respect of this point. That whether the deduction of the Jirat compensation was directed by the reference court in respect of them was correct or not.
Please read F again, once again.
That ground, my lord, yes.
Yes.
Page 16, my lord, para F.
Yes.
May I read, my lord? For that, the learned court below, while passing the impugned judgment and order, failed to appreciate the fact that the concerned record reveals that the landowner appellants were awarded Jirat for tea bushes, shade trees, and shade staff quarters amounting to rupees 67,62,820, assessing an area of 83 bigas, 2 kathas, 5 lechas, and on the other hand,
No, where are you reading?
para F, page 16, my lord.
Page 16.
Page 16, my lord.
Of
In LA appeal number 2 of 2019.
LA appeal number
3.
It is, now there was some mistake in it is 3. Anyway, my lord.
No, the figures are different.
Figures are different.
Therefore,
That is 3 in respect of LA appeal 3.
3, so.
Initial.
Okay. All right. Continue. Continue. So it will be 3, my lord. Page 16.
Yes.
Para F, my lord.
Yes.
For that, learned court below, while passing the impugned judgment and order, failed to appreciate the fact that concerned record reveals that the landowner stroke appellants were awarded Jirat for tea bushes, shade trees, and staff quarters amounting to rupees 67,62,820, assessing an area of 83 bigas, 2 kathas, 5 lechas, and on the other hand, paid Jirat compensation amounting to rupees 2 crore 92 lakhs 87,116 to the encroachers, assessing an area of 146 bigas, 1 katha, 10 lechas as in their occupation, showing tea bushes, shade tree, fencing, culvert of the land owner appellants as owned by them. Out of the said amount, only 53 lakhs 56,600 was paid to them as value of their structures, which Lord should kindly see here. The total land was 146 bigas as against only 83 bigas in respect of the appellants. Now, total compensation was 2 crore 92 lakhs, which included a Jirat compensation of possibly only 53 lakhs as value of their structures. Now the sentence is important. Which facts substantiate that the encroachers were given double Jirat compensation as compared to the landowners' appellants? But the learned court below, while passing the impugned judgment and order, overlooked the said aspect of the matter, and as a result of which passed by the impugned order in a mechanical manner.
What it means? double jirat compensation.
It's very difficult to understand. Double GS compensation, if your lordship, if they mean to say that whatever amount I was given, they were given double the amount, that also, then also it doesn't reconcile, my lord. Because they were given 67 lakhs, present respondent, my lord, appellants.
No, but why are you referring to this
I am
paragraph? What is
referring
your
to-
submission?
My lord, my submission is twofold, my lord. First is, so far as the reasoning given by the learned reference court is concerned, they did not say that the learned reference court committed any error in deducting that amount of jirat compensation by assessing or accepting the market value of the land at rupees 3 lakh. They could not say anywhere, in fact, they have not taken any plea, subject to correction, my lord, that the learned reference court has committed an error in deducting the amount of compensation in respect of jirat is concerned, 85 lakhs in one case, 67 lakhs in another case, by holding the value of the land at rupees 3 lakhs per bigha, where the learned reference court has justified this my lord, order of deduction, saying that whenever a sale permission is obtained in respect of a plot of land, that sale permission, in order to ensure that the government is not deprived of the value of stamp duty and fee of registration, the whole value of the land, including any tree bushes, structures standing on the land, will always be there. And that is how, if unless they say that it was a value of land of a vacant plot of land, matter would have been different. Even in the appeal also they have not taken. See, the record says that it was actually value of a land which was actually vacant plot of land, and there were no
So the
structures.
value of land
My lord.
always include the value of jirat.
Yes, madam. For the
Then,
sale permission. Lordship will kindly say
then
for
what
the
is the necessity of secondly in section 23?
My lord, that's what I'm saying. My lord, here is a case where had the, because the court, normally, my lord, what happens? Normally, my lord, the lordship is aware, the sale deed of an adjacent plot of land, certified copy of a sale deed of an adjacent plot of land is given in order to enable the collector or the reference court to determine the value of the land. Here, my lord, they have given a sale permission in respect of a T patta land. Now, the finding of the reference court is that when you have given a sale permission in respect of a T patta land, normally the sale permission will mean that the sale permission is in respect of a plot of land which
including
not only the tree bushes, my lord, any structure standing thereon, because in order to enter, because it is done by the government authority, they will see that whatever total value of the land is land along with the structure standing thereon is being transferred from one person to another. I have to take the registration fee and the stamp duty in respect of the total value of the property which is being transferred by way of a registered sale deed.
okay.
And that is why the court said if it was in respect of a vacant plot of land, they should have brought some materials. They have not brought any material. Now, in the appeal also, they have not taken any ground. Let's see, the learned reference court was wrong in deducting the value of jirat compensation when the value of the land, market value of the land was assessed to be 3 lakhs on a particular reasoning. That is my submission. And for that matter, I am relying on the judgment. If they say that possibly they did not mean, I do not know what is the meaning. They say we're given double jirat compensation. If they mean by this ground that see, the jirat compensation was given twice to the encroachers, then this reliance on the judgment will be relevant, which says that merely because the respondent authority has passed one illegal or unwarranted order, it does not entitle the High Court to compel the authority to repeat that illegality over again and again. The illegal unwarranted action must be corrected if it can be done according to the law, indeed, wherever it is possible. The court should direct the appropriate authority to correct such wrongdoers in accordance with law. But even if it cannot be corrected, it is difficult to see how it can be made a basis for its repetition. That's my suggestion.
Yes, Mr. Leader.
Here, Lordship, from the review petition, it emerges that the review petition has been filed by the collector only on one ground. The ground is Exhibit 44 cell permission is for tea plantation land. The value is therefore this valuation includes the value of the tea bushes,
Yes.
and therefore Zirat amount already paid is not deducted. It would result in double payment of the Zirat compensation. And we, the appellant, failed to challenge the finding of the reference code, enhancing the value of the land on the basis of Exhibit 44. So that is their whole ground. So my submission is that the finding of this honorable court on the issue number 4 is based on a clear finding arrived at paragraph number 58, 59, and 60 of the judgment, Lordship. So may I read the 60, paragraph number 60 once?
Yes.
Paragraph 60. Page 72. On perusal of the aforesaid provisions, it appears that as per section 23(1) of the Land Acquisition Act 1894, the head of compensation against market value of land and damage to Zirat are shown separately. First and secondly, respectively of the section 23(1) of the Land Acquisition Act 1894, which leaves no ambiguity regarding the fact that the loss suffered due to component of Zirat must be assessed separately from the market value of the land itself. Hence, the compensation assessed against the damage caused to Zirat cannot be deducted from the compensation assessed against the market value of the land at the date of notification under section 4 of the Act. Therefore, the impugned judgment and award of the reference code to the extent of it deducting the Zirat compensation of 67,62,820 only already paid to the appellant from the total compensation for the acquired land at the market value of rupees 3 lakhs per biga is found to be contrary to the statutory provision and accordingly hereby set aside. So this finding is a clear finding on the point raised by the deputy collector in the review petition.
May I be excused for a minute, and the matter is being called in division bench.
So my submission is since this honorable court comes to the finding by giving due and specific reasons. So therefore, such finding based on reasoning cannot be challenged in a review petition. Lords.
No, their submission is that in para 60,
Yes,
the reasoning given by the reference court
yes.
that why separate Zirat compensation is not required to be paid
Yes.
is not discussed. And
That is discussed in view of section 23(1) of the Act. So section 23(1) of the Act, secondly, states that the Zirat has to be separately assessed. Both the component has to be separately assessed. So therefore, that is based on the clear finding in view of section 23(1) of the Act. So therefore, there is no error apparent on the face of the record, and therefore this review application is not at all maintainable. This is my first. Second, my learned friend, referring the ground number F of the appeal memo, that is our contention is that for 83 bighas, 2 kathas, 5 lasses of land, the landowner has been given Zirat of 67,62,820. Whereas for 146 bigha, 1 katha, 10 lasses of land, the encroachers were paid Ziras to the tune of 2,92,87,116. That is double than the amount paid to the landowner. So that is our concern. If the rate is similar, then we will get more compensation, because in the record already produced by the deputy collector, there is a letter where states that where the government has instructed the deputy commissioner to consider 1200 number of tea bushes per bighas of land while calculating, assessing the compensation amount. But in this case, what happened? So far the enforcers are concerned, while considering their jirat, the deputy collector assessed 2400 of tea bushes per bighas of land. But in our case, landowner, it is calculated 1203 per tea bushes of land. So therefore, landowners for the small area get more, then we get less 50%. And the remaining part 53,56,000 that is mentioned in this paragraph, that is that out of this 2,29,87,000, landowners was awarded 53,56,600 for their houses, and the remaining part is given for the tea bushes only. So that our submission is that since the enforcers were given the jirat as per that letter of the government, so we are not paid to the paid at the same rate. So therefore, we are entitled for the same amount as has been awarded to the enforcers.
Okay, anything else?
Lordship, in this regard, I want to place a judgment, Lordship. So because since this the judgment has been passed this honorable court with a clear finding on the issue number 4, so therefore that review petition that cannot be reopened by way of a review petition, Lordship. Paragraph number 25 of the judgment law. Citation to by the 2022 17 SCC 255. Here several judgment has been discussed. Paragraph number 25.
Yes,
Mary.
yes.
Under the grab of filing a review petition, a party cannot be permitted to repeat all on overrule argument for reopening the conclusion arrived at in a judgment. The power of review is not to be confused with the appellate power, which enable the superior court to correct error committed by the subordinate court. So this point, my learned friend arguing in the review petition has already been argued at the time of hearing the appeal, and that was negated by the judgment by paragraph number 60 of the judgment. So therefore, this review application is not maintainable.
Okay.
So this is my judgment. Then next page, it's marked as 20.2. Next page of the judgment. Next page of the judgment.
Which judgment?
I'm relying on just paragraph number 25. It's continuing in the next page 26. Then there is the point of 20.2.
Yes.
Here, when the review will be not maintainable, that's criteria has been given. A repetition of all and overall argument is not enough to reopen concluded adjudications. So this argument already been advanced during the course of the appeal. Parameters has been given when the review will be not maintainable. And regarding the self-permission, my lord, my learned friend try to project the in a self-permission, it includes the value of the all structures and trees. That is not correct, lordship. If I applied for a self-permission where a house is there, then always deputy commissioner, there is a formula PWD rep. Land is assessed separately. Then for house component, it's separately in Gauhati. I think it is 1770 per square feet as per the PWD rep. And another aspect of the matter, if any tea land is allowed to sell by the government, then there must be no tea bushes available. Otherwise, government will not allow to sell the land for any non-tea purposes. Here, this 23 acres of land was allowed to sell to the allowed the appellant to sell because there is no tea bushes. Because where tea bushes are there, that land can be transferred only for the tea purposes. Special cultivation. There is two riders.
On what basis you are saying, sir?
Because if permission has been obtained for transfer of a tea land, there is two criteria. If a garden is sold for tea purposes, then a purchaser will then do the same cultivation, then permission is accorded. Another is if there is in the garden the unproductive land where tea cultivation is not feasible and there is no tea bushes, then government will grant permission after observing all the formality. So here now we get a letter on the basis of which this exhibit 44 was issued, but we cannot produce this, where it is clearly mentioned that the land allowed to sold is a vacant land without any tea bushes.
Where it is mentioned?
Yes, boss. There is a letter subsequently we have got. Before granting the sale permission by the government, Deputy Commissioner forwarded a report before the Secretary, wherein it read that with reference to the above cited, I have the honor to inform you that the proprietor of Being Tea Estate want to sell the above mentioned land due to acute financial crisis. In this connection, spot verification was made and found that the land in question is vacant land and there is no tea bushes. Bushes. Government was pleased to accord permission to sell 18 bigger 3 katha 7 lashes of land of beheating places which is adjacent of the left place under reference.
This is in connection with exhibit 44,
Exhibit 44. Before issuing the exhibit 44, Deputy Commissioner has forwarded
but
this
that
letter.
is not on record.
Not on record. So therefore, I am not giving. So, but this is the fact.
Okay.
Because if a tea land is allowed to sold, there is two criteria. One, if there is a tea bushes, that is not allowed for selling for non-tea purposes. So this is my submission, Lordship.
Okay.
So review application is not maintainable at all, Lordship.
And your review application?
My review application, Lordship, basic on three grounds, Lordship. Though there are several grounds, only basically 3 grounds.
Let us,
Here,
no,
why?
let us take the review. Mr. You have any submissions?
Basically, I'm a beneficiary. I put in the two stalwarts. One is the government of Assam and one is the land owner. Now the government also acquired the land and minority was given to us. Now we have established this industry, discipline industry. So in our application, my lord, the additional advocate general appeared for behalf of the government of Assam and the petitioners council also. And they also agreed, my lord, yes, they don't have any claim against us, my lord. Then lordship, I've given the order last occasion, but I can give also another this to court. I but still I got.
You are appearing for?
Like they don't have any claim against us.
Appearing for a requiring department. Also.
Yes, in earlier occasion, my lord, this matter.
Okay. In this review petition, they are not the parties.
Yeah. In his case, I'm a party.
In my case, he's a party.
It's a formal party. Just since I was initially there,
Okay.
that's the reason. Otherwise, I've got nothing to do. They've got nothing to do with me.
Okay.
And no fight against me.
Because initially there is a tussle between the acquiring department and the requiring department. So therefore, requirement department has also earlier filed LA appeal challenging the judgment, and ultimately state has come and stated before this court
In
that
the review application by government, you are not the party.
not party.
No, I'm not party. I'm party only in his case. Two killings.
Mitaliko. Heard Mr. D. Mujumdar. This is in review application number 292 and 293, common order, 292 and 293. Heard Mr. D. Majumdar, learned additional advocate general, assisted by Miss D. D. Burman, learned government, learned senior
Additional senior government.
additional senior government advocate, appearing for the review petitioner. Also heard Mr. S. Teka, appearing for the respondents.
Respondents.
The hearing concluded, judgment reserved. And your review application,
Yes, Lordship. My review
Number?
application is basically on 3 points, Lordship.
what are the numbers?
My number is 285
285,
and 286.
285 and 286.
285 maybe second.
Yes. 285 and 286. We are taking up 285.
Yes, Lordship.
My lord, since my submission, this is my submission, my lord, this is one matter, according court number.
Yes,
my
yes.
submission which-
I'll show your presence.
Yes, my lord, my submission basically is nothing.
Here, Lordship, while assessing the land compensation by the deputy collector first, the land component was separately assessed and then Jirat was separately assessed. And thereafter, upon both the amounts, 30% solicium was awarded as per section 23(2) of the Act. But in view of the reference court judgment directing to deduct the 85 lakhs, the government has deducted also the solicium part. So since this honorable court held that the appellants are entitled for the 85 lakhs, which has already been deducted, but inadvertently in the judgment, there is no reflection about the solicium under section 23(2) of the Act, Lordship. At that time, nowadays it's 100%. At that time, there 30% of solicium.
23.
Of the Act.
Okay.
May I read the 23(2), Lordship?
Yes.
In addition to the market value of the land as above provided, the court shall in every case award a sum, that is within bracket 30% on such market value in consideration of the compulsory nature of the acquisition. So it is a compulsory component, but inadvertently that was not reflected in the judgment.
And the reference court also made,
Yes, reference code has also given solicium on the enhanced part. But moment this reference code directed to deduct the Jirat amount 85 lakh. So while paying the amount, deputy collector also deduct the 30% over 85 lakh.
Okay.
So that has to be clarified in the judgment. So this is the first point.
okay.
Second point is that in the judgment, Lordship, your Lordship has held that the appellant will be entitled the interest, statutory interest as per the Act over the said 85 lakhs amount. So basically, as per the Land Acquisition Act, 3 type of interest the persons are entitled. One under section 23(1)(a), then one under section 28, and then under section 34. So that has not been clearly mentioned. So if that is not clearly mentioned while making the payment, the government will again put query whether they are entitled. All these interest part are statutory in nature over the 85 lakh. Section 23(1)(a).
Yes.
In addition to the market value of the land as above provided, the court shall in every case award an amount calculated at the rate of 12% percentum per annum on such market value for the period commencing on and from the date of publication of the notification under section 4, subsection 1, in respect of such land to the date of award of the collector or the date of taking possession of the land, whichever is earlier. So from the date of notification till the award is passed or the land is taken over, is entitled to 12% over the amount.
In this case, which one is earlier?
In this case, Lordship, publication notification was published on 6/7/2006 and award was passed on 23/3/2007. Possession was subsequently taken over. So till award it will come.
23/7.
23/3/2007.
This award by reference court or by the collector?
Collector has already given, but moment the reference court directed to deduct the 85 lakh. So therefore, while making the payment, collector has deducted this amount also.
Okay.
Then is under section 28, Lordship. Lordship. Lordship.
Yes.
If the sum which, in the opinion of the court, the collector ought to have awarded as compensation in excess of the sum which the collector did award as compensation, the award of the court may direct that the collector shall pay interest on such excess at the rate of 9% per annum from the date or on which he took possession of the land to the date of payment of such excess into the court. Provided that the award of the court may also direct that the where such excess or part of thereof is paid into court after the date of expiry of period of 1 year from the date of which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year and on the amount of such excess or part thereof which has been paid to the court before the date of such expiry. So under this interest was initially not paid, but the reference course was awarded. But moment this 85 lakhs was deducted, this interest is also deducted.
Okay, on 85 lakhs.
Yes, 85 lakhs.
Okay.
Then under section 34 also.
Yes.
When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at the rate of 9% per annum from the time of taking so possession until it shall have been so paid or deposited. Provided that if such compensation or any part thereof is not paid or deposited within a period of 1 year from the date of which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of compensation or part thereof which has not been paid or deposited before the date of such expiry. So this amount was also not
When
paid.
the possession of acquired land was
Possession was taken over on 28/2/2008. So this amount also not paid by the collector. Subsequently, reference could allow this, but while deducting 85 lakh, this amount was also deducted. So these are the statutory payment. So that has to be clearly reflected in the judgment also. Then third ground is that along with the record produced by the deputy collector, here is a letter whereby the deputy commissioner was directed to assess the Jirat compensation by considering 2400 tea bushes per bighas of land. And accordingly, while assessing the Jirat of the encroachers, the 2400 tea bushes per bighas of land has been considered. But in case of the appellate, that is considered as 1203. So that amount has to be given to the appellant claimant also. If lordship go to the assessment sheet, it will reflect in respect of all the encroachers, per bighas of land has been considered 2400 tree bushes. But in case of the appellant, it's somewhere in 1300, somewhere in 1203. Because government have issued that letter, because in a tea garden, it is difficult to assess each and every tea bushes. Counting of tea bushes is not possible in a whole tea garden. So therefore, government formulated a guideline. For per bighas of land, 2400 has to be assessed. So in this case,
No, whether you can take this plea in review application.
that is taken in the main appeal also. But your lordship has negated that point.
So you have to go.
Yes,
Right.
therefore I am not commenting. But this is error because the assessment sheet itself shows. So therefore is a ground of review. If lordship go through the assessment sheet, it will reflect so far the encroacher is concerned, everywhere 2400 tree bushes has been considered. But in our case, it is somewhere in 1300, somewhere in 1203, somewhere in 1205. So as per my opinion, sir, this is error apparent on the record as per the exhibit laws.
Okay. Yes.
In the, our part of reply, lordship, my learned additional advocate, he is on legs in court number 1. Lordship. For pass over for the time being, lordship, our.
Okay,
reply.
let him come.
Yes, lordship.
So, for the time being.
একটু হলে আগে যাবো।
No, why it has come in orders?
So it has come for hearing, the hearing is already complete, my manager wanted to file a list of arguments, that is for it is.
Okay, you are ready?
I'm good.
Heard Mr. A.J. Sakya, the learned counsel for the appellant. Also heard Mr. M. Talukdar, the learned counsel for the respondent. Who has submitted and in anybody else? No. Learned counsel for the respondent who has submitted written gist of argument as directed by this court on 14/7/2026. The hearing is concluded. Yet, part dictation assembly. Hearing concluded, judgment reserved.
But in respect of some other matter, lordship,
I have already submitted recently the written argument, but there are some mistakes and some handwritten is there. So I am going to file a fresh lawsuit. Today,
Which
I have
matter?
to-
269,
Lawsuit,
269
lawsuit, I am filing a fresh.
today. Okay.
Item 9 and 10.
Wait, please, Your Lordship.
Yes.
Wait, please, Your Lordship. Lordship had heard item number 10 in part on the last occasion. Right.
In item number 10, my senior has engaged in vote number 4, Your Honor. Matter may be taken up this time.
Yes, let him come. Okay.
Let him come.
Lordship, I may start the evidence.
Here in code number 25, go through this.
Just only half an hour will fail.
Lordship will permit me to submit my part.
No, let him remain. What is the matter?
Lordship, it's essentially a conviction under section 20B2C of the NDPS for 10 years for possession of cannabis. We have been sentenced for 10 years. Both of us have served around 6 years. So that is essentially the matter. Our ground is threefold.
You are for the appellant,
I am for the appellant, Lordship, in item 9.
and Mr. Medhi is also for the appellant.
Yes, he is for the other appellant.
So are your submissions are similar?
Essentially similar in nature, Lordship. On the last occasion, he had made his submissions in part. So it had been left over because I could not make my submissions on that day. Should may allow me to make my submissions?
Yes. Hey, Sam. Item number 10. 10. Very long. Item number 10. We'll take it up after a short, I'm taking it.
I mean, item number.
144. Whether it was heard in part,
Yes, my lord. I have raised 2-3 points, major points, my lord.
but there is no indication. Number 10 of order.
Uh, 26/5/26.
Okay. You refresh my memory. What?
Yes, my lord, first, my lord, our submission is that in this case, neither the contraband nor any inventory, it was exhibited, my lord. So the prosecution has failed to exhibit the very basic, my lord, ingredient of this Narcotics Act, my lord, because the prosecution has to exhibit either
How many accused were there?
my lord, 2.
Both the appellants in separate appeals.
Yes, my lord.
Okay. Yes.
My lord, that was our first point, my lord. The Alice contraband was not exhibited, and there was neither the inventory is prepared or exhibited in this case, and that is an admitted position, my lord. TW7 Raja Isar. That's my lord, may kindly take up the IF 45623, my lord. There we have annexed these evidences, my lord.
Ramesh, IF 456.
456. There, my lord, at page 82, my lord. Page 82, it is the evidence of SI Raja Isar, my lord. So on page 82, 3, 4, fourth line from the top, my lord.
Yes.
I have not prepared any inventory in connection with this case. I have not submitted any complaints report to higher authority. So this is an admitted position that inventory was not prepared in this case.
No, he has not prepared. Whether anybody else.
No, my lord, no, nobody. Because the seizing officer has also deposed nothing about that.
He is the investigating officer.
Yes, my lord.
PW.
PW 7, my lord. And in the list of exhibits, my lord will not find the any material exhibit showing the contravention, my lord. So my lord, here I'd like to rely on two judgments, my lord.
PP. Yes. Good.
First, my lord, Jitendra and another state of MC, my lord. My lord, at page number 3, para number 6. In our view, the view taken by the High Court is unsustainable. In the trial, it was necessary for the prosecution to establish by cogent evidence that the alleged quantities of charas and ganja were seized from the possession of the accused. The base evidence would have been the seized materials, which ought to have been produced during the trial and marked as material objects. There is no explanation for this failure to produce them. Mere oral evidence as to the features and production of Panchnama does not discharge the heavy burden which lies on the prosecution, particularly where the offense is punishable with a stringent sentence as under the NDPS Act. In this case, we notice that the Panchas have turned hostile. So the Panchnama is nothing but a document written by the concerned police officer. So, in that light, my lord, acquittal is given in this case. So, my lord, when in NDPS cases, my lord, when these materials are destroyed, sometimes, my lord, with the permission of the court, then this inventory becomes a substitute evidence, my lord, production of inventory. But in this case, admittedly, it was not prepared, my lord. So there is neither the substance nor the inventory. In the second case also, this Ashok Dangra Jaiswal versus State of MP, the same this case of Jitendra and another was referred, my lord. The same position was held, my lord.
Which para?
Para 13, my lord, page number 4. It may be noted here that in Jitendra and another versus State of MP on similar facts, this court held that the material placed on record by the prosecution did not bring home the charge against the accused beyond reasonable doubt, and it would be unsafe to maintain their conviction on that basis. In Jitendra Supra, the court observed and held as under. So that observation was observed again. And at para number 14, my lord, the decision of Jitendra applies to the facts of this case with full force. We accordingly hold that the appellant is entitled to the benefit of doubt and acquit him of the charges and set aside the judgments and orders passed by the trial court and the High Court, my lord. And in our case also, this the facts and circumstances of this case also, this judgment applies, my lord.
In this case, Caesar list was exhibited.
Yes, my lord. I am coming to that, my lord. So materials they fail to prove. Caesar list also they fail to prove. But in Jitendra, this Jitendra and another in this case, they said that if the materials are not produced, my lord, production of this Panchanama, that will not do. But here, my lord, they have exhibited, but they have failed to prove the seizure list as well. Why? All the seizure witnesses, they have stated differently, my lord. My lord, may kindly come to page number 66, my lord, of the IA. That is the seizure list.
Just a minute, just a minute. Mr. Majumdar, we'll take up the matter at 2
All right,
because this hearing may go long.
no difficulty.
We'll take,
Division matter just now got over.
we'll take it up at 2.
Fine.
Yes, continue.
My lord, kindly come to page number 66, my lord.
66 of
66 of this IA, my lord. This is the seizure list pertaining to seizure of 30 kgs of ganja, because in the FIR, it was alleged that 30 kgs was seized on the spot. And after that, at the instance of the accused, another 75 kg was seized from the house of one Jayanta Daimari. So, prosecution alleges that there were two seizures, 130 kg and 175 kg. Now, this at page 66, exhibit 2, it is the seizure list of this 30 kg. Madam. So, this is the seizure list. I understand do hereby seize the below mentioned articles from the possession of Habibul Islam and Nijud Bormohlia in connection with the above referred
but
case.
seizure list shows that 30 kgs were seized.
Yes, my lord.
Why to disbelieve?
Yes, my lord, I'm coming, my lord. The seizure has been made in presence of below signed witnesses and as per law, my lord. So this says that it was seized in presence of the below signed witnesses, my lord. And the witnesses are number 1, Chandra Deka, my lord. Chandra Deka, PW1, and Sudama Panika, is PW3, my lord. Now, the evidence of this PW1 Chandra Deka, my lord, will find at page number 61. Page number 61, my lord.
Yes.
Yes, my lord. Page number 61. I know the informant SI Rohit Kumar Chetri of Masbat Police Station. I do not know the accused persons. About 1 year ago, on one day, the police of Masbat Police Station took my weighing scale to the police station. Later on, I was called to bring back my weighing scale. At that time, police stated me that the weighing scale was seized. Exhibit 1 is the seizure list by which my weighing scale was seized by police. Exhibit 2 is the seizure list by which one vehicle and 30 kgs of ganja was seized by police. Exhibit 3 is the seizure list by which packets of samples of ganja was seized. Exhibit 4 is the Jimmanama by which my weighing scale was returned back to me. Now, my lord, here in his deposition, he speaks about seizure of his weighing scale. He deposed nothing about seizure of this ganja, my lord. Then he identifies his signatures in the seizure list, my lord. And during cross-examination, my lord, he says, I cannot recollect the time when my measuring scale was taken by police. My signature on seizure list were taken at the police station, my lord. At the time when police asked me to bring back the scale, I did not put any signature when measuring scale was taken away. I cannot say what was written on the paper, nor it was explained to me by police. I did not see the seizure of any vehicle or any contraband articles except my measuring scale, my lord.
Okay.
And this is not a hostile witness, my lord. So these are admitted position. So he completely negates the seizure list. Now second PW3, my lord. Second seizure witness, Sudama Panika. My lord will find at page number 64. Sudama Panikar.
Yes.
Yes, my lord. I do not know the informant. I also do not know the accused persons. The occurrence took place in the year 2020. On one day at about 7:30 a.m., the police of Masbat PS called me over phone. Then I went to Masbat PS. Then I came to know from police that one Bolero vehicle was seized by police. Now here comes a very different vehicle, my lord. In the FIR, it was a Swift Desire. Now here, this witness was called because there was a seizure of one Bolero vehicle. Now, police obtained my signature in 5 seizure lists because at that time I was the VDP secretary. Exhibit 4 and Exhibit 5 were the seizure lists, and Exhibit 4, 2, and 5, 2 are my signatures. Exhibit 3 is the seizure list by which sample of ganja was seized. Exhibit 3, 2 is my signature. Exhibit 2 is the seizure list by which the Bolero vehicle was seized by police. And this is my signature. Exhibit 1 is the seizure list related to one weighing measure. Exhibit 1, 2 is my signatures. Now in cross-examination, it says, my lord, police obtained my signature in the seizure list at the police station. Police obtained my signature because they seized the Bolero vehicle. I do not know whether any other material was found on the vehicle or not. So, my lord, and he is also not hostile, my lord.
And only one seizure list was.
No, and second seizure list, my lord, that is page at 69, my lord. Regarding that seizure of 75 kgs of ganja. And that was seized, allegedly seized from the house of one Jayanta Doimari, my lord. 69, page number 69, my lord. And here, the second witness, Sudama Panikar, is common, my lord, which I have just read. And witness, witness number 1, there is Birmal Doimari, who is PW2. My lord will find at page 62, my lord, his evidence. Page 62, my lord.
Yes.
I know the informant Rohit Kumar Chetty of Masbat PS. I do not know the accused persons. About 2 years ago, one day the police of Masbat PS went to the residence of Jayanta Doimari of our village. I came to know that police recovered the ganja from the house of Jayanta Doimari. Police seized the ganja packets and obtained my signature in seizure list. Exhibit 4 is the seizure list and Exhibit 4.1 is my signature. Exhibit 5 is the seizure list by which sample packets of ganja was seized. Exhibit 5.1 is my signature. Now, in cross-examination, my lord, on the date of seizure, I did not notice the accused persons at the house of Jayanta Doimari. So police obtained my signature in the seizure list at my home, my lord. He says his signature was taken at his home. I did not went to the house of Jayanta Doimari at the time of recovery of ganja. No ganja sample was shown to me by the police. So the story of the prosecution is that at the instance of the accused, this 75 kg was recovered from the house of Jayanta Doimari. And Birmal Doimari witnessed the incident. But Birmal Doimari, he says, he did not go to the house of Jayanta Doimari, neither he saw the accused persons at the time of recovery, and his signature was also taken at his own home, my lord. So how did you witness that seizure, my lord? And the other witness, Sudama Panikar, which I have already read, he have stated nothing about seizure. So,
One more witness is there.
no, my lord.
No, one more witness is there, Mr.
One more witness, my lord.
Habibul.
Habibur is accused, my lord. He's the other accused, my lord.
Okay. He is also shown as witness.
But
No.
he is not testified, my lord. So,
What are the names of accused?
one is
Habib-
Nijut Bormoholia,
Okay. Only 2 witnesses.
and another one is
Publicly Islam.
Habibul Islam.
So seizure has not been proved.
That is second. And third, my lord, most important, the link evidence is completely missing, my lord, which is very much vital in NDPS case. There is, and my lord, samples were not drawn before magistrate, admittedly. Because at page 83 and 86, my lord, there are two seizure lists pertaining to seizure of the samples, my lord.
Yes.
My lord, kindly come to page 83. Page 83, my lord. This is a seizure list pertaining to seizure of samples, my lord. I undersigned to hereby seize the below mentioned articles on sample package numbered as A1, A2 in connection with the above referred case. The seizure had been made in presence of the below signed witnesses as per law. Two sample packets suspected cannabis and weight 25 gram is marked A1 and A2, and sign of seizing officer Rohit Chetri, date 15 to 20, and at Masbat PS, madam. So these samples were not seized or drawn before the magistrate, madam. And another is at page 86. This is and these samples were seized and drawn at Rota Majoli Gaon, madam, not before magistrate. And next, my lord, the link evidence, my lord, because there is no evidence that whether how these samples were drawn in packets, containers, whether they were sealed or not. If sealed, what was the impression of the seal? There is nothing, my lord. Because the seizing officer, Rohit Kumar Chetri, who has seized these articles, he says that
He is PW?
he is PW5, my lord. My lord, you will find it page 73. Very interestingly, he has seized all these things, but he says that the ganja and the samples were not sealed in my presence. I sealed the packets in front of magistrate. This is the version of seizing officer, my lord. Rohit Kumar Chetri, PW5 at page 73. I'll take your honor to the relevant line, my lord, at page 76, third line, my lord, from the top. 76. Third line from the top. The packets of ganja and sample packets were not sealed in my presence. Later on, the IO sealed the packets in presence of magistrate. So this is the deposition of seizing officer.
No, but you have submitted that samples were not taken in presence of magistrate.
No, yes, that is admitted position. But here he said that it was not sealed in my presence. He has taken the samples. That is an admitted position because it's a seizure list. It is his signature. It is there. In evidence also he has said he has taken, but he says that it was not sealed in my presence. Later it was seized by the IO in presence of magistrate. Means he took the sample before the magistrate, then he sealed there. That is what it can be made out from his statement.
What IO has said, whether.
Yes, my lord. Now what I have said, my lord. PW7, my lord. PW7, page 80, my lord. He has deposed nothing about sealing, my lord. What he has deposed at page 81 regarding the search and seizure were prepared by informant SI Rohit Kumar Chetri. That must. And at page number 80, my lord, he said that on 16/2/2020, I produced the seizure list along with the seized articles to make this seen by magistrate. Sample packets were sent for FSL examination through SP Udalguri. So he says that he has produced those seized articles along with the seizure list for the purpose of making them seen by the magistrate. But he has deposed nothing about sealing. And in cross-examination, he says that the search and seizure were prepared by informant Rohit Kumar Chetri. So from this evidence, it cannot be made out, my lord, that who has actually sealed it or not, my lord.
When sample were drawn?
My lord, on 15/2/2020, my lord.
Where is that?
My lord, in that seizure list, my lord, pertaining to seizure of the samples, my lord. 69 and 86 pages. 83, my lord. Page 83
Okay, okay.
and page 86, my lord. And my lord, as per the FSL evidence of this officer from FSL, my lord, these samples were received on 19/2/2020. But from 15/2/2020 to 19/2/2020, my lord, almost 5 days, my lord, or 4 days, where these samples were kept. There is oral evidence, my lord, that it was kept in Malkhana, but admittedly, there is another evidence that I have not produced the Malkhana register. And the position is very much settled, my lord, that this custody is to be settled by bringing the Malkhana register, my lord. Oral evidence will not. So the link evidence is also free. So in that regard, my lord, some judgments are there, my lord. Some judgments, my lord. First, my lord, this state of Rajasthan versus Gurmail Singh, my lord, at para number 3. We peruse the judgment of High Court. Apart from other reasons recorded by the High Court, we find that the link evidence adduced by the prosecution was not at all satisfactory. In the first instance, though the seized articles are said to have been kept in the Malkhana on 25/1995, the Malkhana register was not produced to prove that it was so kept in the Malkhana till it was taken over by PW6 on 5/6/95. So, my lord, here there is discrepancy about only 1 day. And here PW6 who took the samples, that was also present in this case. But in our case, that who took the samples to the FSL, that is also not there, my lord. We further find that no sample of seal was sent along with sample to the excise laboratory, Jodhpur, for the purpose of comparing with the seal appearing on the sample bottles. Therefore, there is no evidence to prove satisfactorily that the seals found were in fact the same seals as we put on the sample bottles immediately after seizure of the contraband. These loopholes in the prosecution case have led the High Court to acquit the respondent. We find no error in the judgment of High Court. So that is one. And second, State of Uttar Pradesh versus Hansras. Here also para 6, my lord. The learned counsel appearing for the state has drawn our attention to the evidence of PW1, Sub-Inspector this, and PW2, who in their evidence stated that the substance which was recovered and sealed were deposited in the police station go down and later produced before the court. Though this witness have stated that the substance was deposited in the police station go down and later produced before the court as pointed out by the High Court, there is no evidence to show as to how and at what time and date the samples were taken by the carriers for analysis. It has also come on evidence that constables Asaram Karamchand have taken the samples of charas and liquor packets respectively to the laboratory were not examined by the prosecution. So here also the messenger in our case is missing, my lord. The High Court has also pointed out that it was incumbent on the part of the prosecution to lead the evidence to show as to how and in what conditions the articles were preserved at the police station and how safely they were taken from there to the respective chemical examiners by its carriers. The learned counsel for the state has submitted that investigating officer in this particular case has passed away and therefore the prosecution was handicapped in adducing the necessary. Notwithstanding the death of investigating officer, nothing prevented the prosecution from examining any other witness who was associated with the investigation and adducing necessary evidence to prove. So, my lord, this Malkhana registry is necessary, which was not exhibited, or the messenger was also not examined, my lord.
Yes, Mr. Atre, you have anything to add?
Only this one point.
So, my lord, may I take leave, my lord? Another case.
Yes.
Obliged.
If I adopt all the submissions made by my learned friend, only essentially there are 4 issues. Firstly, that there is a violation of section 52A. The inventory was not prepared. The second aspect, lordship, is the chain of custody of the contraband is completely vitiated.
Yes.
The seizure was never proved independently, lordship. All the seizure lists, therefore, stand vitiated, including the samples that were collected.
Yes.
As far as the chain of custody issues are concerned, my learned friend has brought to the notice of this court that samples were not taken, and secondly, that Malkhana register was not produced. So that I will not elaborate. Only one judgment of lordship's Manirud Zaman I would just rely on, because in Manirud Zaman also, it was a case of 52A as also violation of chain of custody. In this case, there is an additional aspect. Seizure has been completely vitiated. So para 50 is lordship of Manirud Zaman. If I may, for my satisfaction rate, lordship, 50 to 54.
Yes.
As para 50. In the instant case, it was required that after drawing of representative samples, a list of such samples should have been prepared containing such details relating to its description, quality, quantity, mode of packing, batch number, or other such identifying particulars of the sample drawn, and thereafter the correctness of the list of samples so drawn should have been certified by the magistrate. However, in the instant case, it appears that no list of representative samples drawn was prepared, and certification regarding the correctness of same by the magistrate does not arise. This seems to be violation of the mandatory procedural requirement as envisaged by section 52 of the NTPS Act. I'll skip over 52 and come 51 and come to 52. There also appears to be force in the submissions of learned counsel for the appellant that chain of custody was not maintained while sending the samples after its withdrawal from the contraband till it reached the forensic laboratory for its examination. It appears that through the PW6, though the PW6 has deposed that the contraband was kept in police station Malkhana, however, apart from oral testimony, nothing was produced to substantiate this evidence. No Malkhana register was produced to show that the samples which were drawn from the contraband were kept in Malkhana before it could be sent to the forensic laboratory for its examination. Lordship will have 54. the penal provisions of the NDPS Act prescribes very harsh punishment for the offender. Therefore, it is incumbent for the prosecution side that the mandatory procedural requirement to be followed by the prosecution in such a case are to be strictly followed. Any lapse on that count would dent the prosecution case and would give advantage to the accused. Lordship will also note that thereafter the judgment of Bharat Ambale has come on 52A, the Honorable Supreme Court.
What it says?
Yes. So Bharat Ambale says that 52A alone cannot be a fatal ground. But this case, in my humble submission, is not only a 52A case. There are all other substantial grounds also. So, Lordship, as far as law is concerned, I would place this. Also, one more factual aspect. Lordship, though there was a seizure of 75 kgs from the house of one Jayanta Doimari, the learned trial court itself has attributed only possession of 30 kgs to me. So that 75 kgs was issued from the evidence. Thus, from ultimately only 30 kgs was attributed to me by the impugned judgment. The judgment itself at Lordship, I'll just point out the paragraph 33.
Yes.
It holds, Lordship, that there is no evidence in record that the other 70 kgs of contraband was under conscious possession of accused Nituj Bormohalia and Hobikul Islam. However, it makes no difference, Lordship, as far as sentencing is concerned, because this is anyway commercial. But just to clarify, Lordship, that has been held by the trial court.
Okay.
That is all.
Yes. Anything?
So firstly, I pointed out one thing, Lordship. In PW6, that is the IO, as my learned friend DK Remedi Lordship has already stated the fact that it is on my this recording Lordship, I'll share. I wanted to point few lines, Lordship,
Yes.
permit me, Lordship. Point number PW5. He has stated that he has already read the lines, Lordship.
Who is
that,
PW5?
PW Lordship, it is not still in his presence, Lordship, that line. Lordship, may kindly give me 1 minute. It is on, later on, IO, that is 45, I think.
PW5 is the IO.
No, Lordship.
Informal.
No, informal, Lordship.
Informal.
I apologize, Lordship, informal. 45. Lordship, 1, 2, 3.
Yes. What?
5 line below, Lordship.
Yes.
Later on, IO sealed the packet in presence of magistrate.
Yes.
And PW6, that is on page 48, Lordship. In PW7, I apologize. Lordship, there is a date. Lordship, get the date, Lordship. On 16/2/2020, I produced the seizure list along with the seizure articles to make this seen by the magistrates. And however, it is stated that samples packets were sent for FSL through examination through SP Udalguri. I have it the later, Lordship, in the record, Lordship, to the Honorable Court of Special Judge Udalguri, prayer for scene of seizure list and seized articles, Lordship. It is there. And in that, MR 05/2020, Lordship, 2 samples packet of suspected cannabis weight 25 gram, each marked as A1, A2. So it has shown to the, it has been made a prayer before the.
No, their submission is sample was not drawn in front, in presence of magistrate. Sample was produced before the magistrate on 16th, but it was drawn on 15th at some other place, which is indicated in the seizure list.
Okay, Lordship. That is not reflected whether it has been drawn before the magistrate or not.
No.
I have not found,
Because
Lordship.
magistrate, it was produced on 16th,
16, Lordship.
but sampling was done, sample was done on 15th itself.
However, Lordship, in the CD portion, Lordship, I have seen that 2 seizure witnesses are also there, in front of whom this sampling has been done.
No,
But I have seen.
but in the
Magistrate, I have not aware of that, Lordship. However,
page 69, sampling was done at Rota Majuli Gaon.
Yes.
On 15 to 2020 at 2 p.m. this is one aspect, sampling.
Yes.
Another is seizure witnesses have denied that there
Okay.
was anything.
Understood, Lordship. But the thing is that there are two seizures are there. These two seizure witnesses are there. At the first instance, Lordship, the seizure, I will rather name it as seizure one, that only the with Lordship, the with missing is there. And
Yes.
they are the same person. And on the second Lordship, seizure, they are also, seizure list is there against that vehicle and this material 30 kg there, Lordship. And in their 161 statement, they have stated that they were
No,
present.
but before the court, they
Lordship,
have,
I understand. Before the
one-
court, it is the duty of the PP Lordship to reflect this to before the learned court, Lordship.
yes.
But it has not been done. It is true, Lordship. I have to sincerely apologize for that. But then the second point, Lordship, I also want to point out another thing that also need to be pointed out. I feel so, Lordship. In PW2, that is, this is the person, Birmal Doimari, Lordship, who went to the place where 75 grams of, Lord, 75 kg of ganja has been found. May I point few lines, Lordship, if my Lordship may point.
Yes.
Though it is not related to him, I just point out few lines, Lordship. On the first examination in chief, Lordship, he has stated that, may I read the line, Lordship? I know the informant so and so, Lordship. I don't know the accused person. About 2 years ago, one day, the police of Masbat went to the residence. I came to know that the police, Lordship, went to the the police of Masbat went to the police of residence so and so, Lordship, and I came to the police, recovered this ganja. Though he has stated that he has not gone to that place, but he has stated that in his home he has been signature has been gone. But in this case also, Lordship, the same thing is said that in his 161, it has to be shown that 161 statement he has completely made a different statement. He went to that place. I apologize. It is true, Lordship, that it is not proved, as because he has stated something else, and he has stated that he has not recovery of ganja. And regarding this seizure, I've already made that he has made a letter is there before the learned court, Lordship, that sample has been shown to the magistrate, Lordship. But as Lordship has stated that but the sampling is done not before police. But I have not found that, Lordship, where the sampling has been done.
Page 63,
Lordship.
page 69,
Okay, Lordship.
page 69. Seizure list dated 15/2/2020.
Lordship.
Sample were collected.
MR number 5 of 2020, Lordship, I believe.
Page 60. Okay.
Here another last point, Lordship. Here one authority letter is also there. I do hereby authorize Sri Rohit Kumar Chetri of Masbat under so and so, Lordship, to seize suspected ganja in connection with Masbat so and so dated 15/2/2020, Lordship. He will obtain sample from each packet in presence of witness at the place of occurrence. And accordingly, he has done.
Okay, heard. Mr. D. Medhi.
May I just point out one aspect before
Yes.
that depicts
Yes.
this regarding this authority letter. In with respect to the IO, he says in his cross-examination that the authority letter was signed on 19/2/2020 and not on 15/2/2020. Lordship, that is a.
IO says.
Yes.
But also one thing is that in his statement, he stated that farewell permission has been granted.
Yes, that is.
That is also there, Lordship.
That is.
In his PW5, it is stated, Lordship. Farewell permission of higher authority obtained at the time of seizure and search and seizure lodge. It is also there in PW5.
That is the informant. The
Right,
IO said that
informant.
it is saying the name.
Mr. D. Medhi, D.K. Medhi, learned counsel for the appellant in criminal appeal number 192/2023, as well as Mr. A. Atreya, learned counsel for the appellant in criminal appeal number 144/2026. Also heard Mr. K. Das, the learned counsel for the learned additional public prosecutor appearing for the state respondent. By this common judgment, this court proposes to dispose of two criminal appeals which arise out of the same judgment of the trial court, namely criminal appeal number 144/2026 by the appellant Habikul Islam, and criminal appeal number 192/2023 by the appellant Nijut Bor Mohulia. Stop. Both the appeals are directed towards judgments and order dated 22/12/2022, passed by the special judge, passed by the Court of Learned Special Judge Udalguri in special within bracket N case number 4/2020, whereby both the appellants were convicted under section 20 within bracket B within bracket 2 within bracket C of the NDPS Act 1985 and were sentenced to undergo rigorous imprisonment for a period of 10 years each, as well as to pay a fine of rupees 1 lakh each, and in default of payment of fine, to undergo further simple imprisonment for 6 months. The facts relevant for consideration of both the appeals, in brief, are that on 15/2/2022, the officer in charge of Majbat Police Station got an information through reliable sources regarding transportation of ganja by two persons in a Swift Desire vehicle from Lalpani towards Majbat. Stop. Accordingly, a general diary entry was made in Majbat Police Station, numbered as Majbat PSGD number 268/268 dated 15/2/2020, and a Naka checking was organized at Bahi Pukhuri line number 12. Stop. Line number 12, Orang Rupa Road. Stop. During Naka checking at about 11 a.m., one Swift Desire within bracket metallic grey colored, bearing registration number AS12P 313916 was intercepted by the police personnel, and two occupants were found inside the vehicle. Stop. During interrogation of the both the occupants, these occupants were the appellants.
Yes, Lordship.
Both the appellants, occupants, within bracket लिखिबो, appellants, they admitted that they were bringing 30 kgs of suspected cannabis in the rear cabin of the vehicle from Rota Majuli Gaon under Majbat police station. Stop. Accordingly, the said suspected 30 kgs of cannabis were seized. Stop. Thereafter, on being led by the present appellants, another 75 kgs of suspected cannabis was recovered from the residence of one Jayanta Daimari at Rodha on the same day at about 2:30 p.m. However, said Jayanta Daimari could not be apprehended. Later on, who lost the FIR?
PW5, Lordship.
What
Rohit
is it?
Chetri, the SI Rohit.
Later on,
Rohit Kumar Chetri, Lordship.
Rohit Kumar Chetri, Kumar
Correct.
SI of police, lost the first information report before the officer in charge of Majgaon police station. On the basis of the FIR, Majbat PS case number 112/2020 was registered under section 20C of the NDPS Act, and the investigation was initiated. So, after completion of the investigation, charge sheet was laid against both the appellant as well as one Jointo Daimari, within bracket showing him as absconder under section 20B2C of the NDPS Act 1985. The absconding, stop. I'm reserving the judgment.
My submission only, I will focus on PW6 lot. There also the seizure lot.
PW,
That is the PW6, that is IO lotship. Under PW5, he has stated that lotship from the vehicle, this materials has been found.
heard so both sides. Hearing concluded, judgment reserved.
Deeply obliged.
Does not come.
It's not there, sir.
Because if we defer it for some time,
Yes, sir.
then you have to wait for a long time. Then we'll take up the other matter. We'll take up after some time.
Yes.
Cited. Session Act. Yes. Yes, Mr. Roy.
My pleasure. Lordship, please to come to page 75 of the memo appeal, which is the evidence of the one of the attesting witness, Minnal Das. I say the Minnal Das, son of so para one, that I am one of the attesting witnesses of the last will and testator of Nitendra Nath Pukan, dated 28/9/2009, and hence competent to cite this affidavit. Para two, that I state that I was present at the time of execution of the will and testament by said Nipendranath Pukan, and so the said testator affix the signature thereto, that the said testator acknowledge the said writing in his last will and testament in my presence. Exhibit 1 by 1 is the signature of the testator Nipendranath Pukan. Para 3, in that I state that said Nipendranath Pukan, the testator at the time of execution of the will was in sound state of mind, and he signed the said will in presence of me and other two attesting witnesses, namely Sri Rajendra Kumar Sharma and Siddhartha Datta, out of his free will and volition, without any being influenced by the portion inducement from any corner. I put my signature of this said will as one of the attesting witnesses, filed by 1/4 is my signature. That the statement, then your lordship, the cross-examination, page lordship 78 of Minnal Das, one of the attesting witnesses. Cross-examination by the appellant defendant. I know Virendranath Pukan, I know Nipendranath Pukan, and now he is no more. I sign in the will in the house of Nipendranath Pukan at Gauhati. Lordship, there is only one house over the land, Assam type house, Lordship, having 6 numbers of rooms, bedrooms here, Lordship. So 2 rooms were occupied by the present appellant, 2 rooms by the petitioner plaintiff, Lordship, and 2 rooms by Virendranath Pukan, Lordship. And there was no partition when the will was executed. Nipendranath Pukan was a resident of Jorhat. Nipendranath Pukan, while coming to from Jorhat to Gauhati, reside in the said house. It is not a fact that I knew that Virendranath Pukan was the owner of the house. I know Nipendranath Pukan about 2 years, and prior to execution of the said will, I met him while repairing a house behind the said house at Gauhati. I was called by Nipendranath Pukan over telephone to sign on the will. At the time of execution of the will by Nipendranath Pukan, 2 other persons were also present at the house of Nipendranath Pukan. I do not know them, and the name is also not known to me. The 2 persons mentioned in the 3rd paragraph above was not known to me at the time of execution of the will, and I do not know their name. By the will, Nipendranath Pukan has given his share of property at Gauhati, his share of property at Jorhat, and share of the estate to Virendranath Pukan. I do not know any of the person. I signed him in the will as I was informed. At the time of preparation of the evidence of the affidavit, I was informed by one unknown person. Accordingly, I came and signed the affidavit. I signed in the exhibit 1 after signing by Nipendranath Phukan. It is not a fact that the exhibit was a blank paper and having only thumb impression of Nipendranath Phukan. It is not a fact that exhibit 1, after writing the contents and and after the thumb impression, Nipendranath Phukan was four signature in the blank space. It is not a fact that the exhibit 1 was fraudulently prepared by Virendranath Phukan with his son. And Lordship, the next attesting witness. Next attesting witness, Lordship, page. No, another cross. Cross of, sir. Page, Lordship, 83. This is the evidence on affidavit of the second contest, attesting witness, Siddhartha Datta, Your Lordship. Your Lordship may come to next page. I state that I was present at the time of execution of the will and testament by said Nipendranath Phukan and saw the said testator affixing his signature thereto, that the said testator acknowledged the said writing in his last will and testament in my presence. Exhibit 1 by 1 is the signature of testator Nipendranath Phukan. That I state that the said Nipendranath Phukan, the testator at the time of execution of the will, was in sound mind, sound state of mind, and he signed the said will in our presence of me and other two attesting witnesses, namely Shri Rajendra Kumar Sharma and Shri Mrinal Das, out of which out of his free will and volition, without being influenced by his by any portion and inducement from any corner. I put my signature on the said will as one of the attesting witnesses. Exhibit 1 by 5 is my signature. Then the Lordship will come to the cross portion. Page, Lordship, 86. Cross of PW3. I am a businessman by profession. My business relates to telecom and my place of business is at Gauhati. I know Virendranath Phukan and Nipendranath Phukan as I was a tenant under them in the year 2017-18. Nipendranath Phukan was a resident of Gauhati and I used to meet him when he used to come to Gauhati. I used to meet to the house of I used to meet him in the house of Virendranath Phukan. I do not know about his ailment. I am a witness in the will, Exhibit 1. As such, I have been called today to depose as witness in the case. Nipendranath Phukan executed the will at his Gauhati residence. I never informed Virendranath Phukan about the will. Prior to the execution of the will, Rajendranath Sharma, Mrinal Das was not known to me. When I went to Gauhati residence of Virendranath Phukan, two more persons were already present. One of them was writing the will. Nipendranath has signed the will first, then we signed as witnesses. It is not a fact that it is not a fact that in between the last line of the will and signature of the testator, I signed as witness. Though I was staying at the house of the Virendranath Phukan. I do not have much contact with him, with his son. But after 2012, his son came to my house and asked me regarding the will. It is not a fact that the Nipendranath Phukan thumb impression was obtained in a blank paper, and subsequently the contents of the will was ascribed, and as there was a gap between the signature and the contents of the will, or put our signature as witnesses to fill up the gap. It is not a fact that the Virendranath Phukan and his son has manufactured the will, Exhibit 1, in collusion with me and other attesting witnesses. So, Lordship, the petitioner appellant has submitted that the will was executed at in the residence of Virendra Nath Phukan. That is not correct, Lordship, because two attesting witnesses have submitted by their affidavit and in pros also that the will was executed in the room of the testator executor Nipendranath Phukan, Lordship. But from that, your Lordship will please to see. अरे हाथे हम लॉन्ग हो जाओ एक ही नहीं Lordship, please to come to page 52, objection filed by the appellant defendant before trial court. Page 52.
Yes. Yes.
Page 52 is the objection filed by the present appellant before the trial court. Lordship, may we please to come to para 5. Only the averments are contradictory to each other. I would like to place. Para 5, last para, that the will in question is a manufactured one. The petitioner in collusion with the witnesses and the writer prepared the will for illegal gain, and as such the probate application is liable to be dismissed. So, Lordship, para 5 says that it is a manufactured will. Then Lordship may come to para 23. Para 23, page Lordship 56. Last para, page 56, bottom. That the statements made in paragraph 11 and 12 of the probate application are not correct and already denied. The answering opposite party begs to state that the so-called will is not at all a will of late Nipendranath Phukan. The same is a manufactured one, and in collusion with the witnesses and the writer, as such the petitioner is not entitled to probate of will. It is not out of the place to mention that the petitioner was found guilty of forging the signature of Nipendranath. Lordship,
In some other letter.
Lordship.
In some other letter, not in the will. Forging the signature of Nipendranath in a letter which you read complete line.
Yes, Lord. Which has forging the signature of the answering opposite party when he forged signature of answering opposite party in a letter. Yes, this is other document. Now, Lordship, here, the appellant submitted in para 5 that it is a for manufactured. In the cross-examination, the appellant admitted no. He is not disputing the signature of Nripendranath Phukan over the will. It means it was admitted that the will was executed by Nripendranath Phukan, Lordship. That portion of the cross-examination, your Lordship may please to peruse.
No, their case is that you took signatures of Nipendranath on a blank paper first and thereafter prepared the will. That is their case.
No, but in the cross, I am placing Lordship. Here they admitted
They are
that
they are not denying the signatures.
if they are not denying the signature, Lordship, then Lordship, what will be its evidentiary value, Lordship?
No, in page 53, para 6. Go to page 53. 53, para 6. That is their case.
Para 6, Lordship, that the petitioner took signature of the testator in the blank papers under due days and caution and and after his death manufacture the will wrongfully to gain illegality.
That is their case.
That is, Lordship, how the petitioner come to know? Because Lordship, appellant defendant, he is a resident of Ireland.
Yes, no, that is their case. And to substantiate this submission, they are pointing towards two facts. The squeezing of paragraph in will, squeezed writing, then taking of signature of the testator below the signatures of the witnesses, and
Lordship,
then non-examination of the writer
it is
has
not
been.
necessary, Lordship.
That is their case.
That is their case, Lordship. Rajendra Kumar Sharma, he was the lead writer. He submitted his evidence on affidavit, Lordship, but due to his ill health, he did not turn up with the cross-examination. But as per the Indian Succession Act, Lordship, the writer is not required to be examined, Lordship, only to at least one witness. If there are more than one witness, even one witness, attesting witness is examined, that is sufficient, Lordship.
Yes.
That is sufficient. Here, two attesting witnesses have deposed that the will was executed by Nripendranath Phukan and they had signed as the attesting witnesses and will is not a forged one. So there is a clear-cut finding, Lordship. And in the petitioner, the averments made in para 6, page 53, that the petitioner took signature of the testator in blank papers under due days. How he come to know? What is source of knowledge or information, Lordship? When he was at that time, he was a resident of Ireland. So this is nothing but the hearsay evidence, nothing else. If would have been present at the time of will, the matter would have been different, Lordship. And the fraud has not been pleaded specifically as required by law, Lordship. Mere that the will is suspicious, it is fraud, it is manufactured, will not do, Lordship. Then your Lordship may please to come to cross. Lordship, may you please to come to page 83. Evidence on affidavit of one Siddhartha Datta, PW3, page 83.
You read already.
No, this I.
Yes, Siddhartha is the attesting witness. You have read it just now.
Lordship, may come to page 84. I state that I was present at the time of execution of the will and testament by said Nripendranath Pukan, and so the said testator affix his signature thereto, and that the said testator acknowledge the said writing in his as his last will and testament in our presence. Exhibit 1/1 is the signature of the testator Nripendranath Pukan. I state that the Nripendranath Pukan, the testator of at the time of execution of the will, was in sound mind and he signed the said will in presence of me and other two attesting witnesses, namely Sri Rajendra Kumar Sharma and Minal Das, out of his free will and volition, without being influenced by any portion or inducement from any corner. I put my signature. Then Lordship, his cross, page Lordship 86. I am businessman by profession. My business relate to. I have placed this. Sorry. And Lordship, the deed writer, chief, page 87. Page 87. Lordship, para 2, that I state that he drafted the last.
No, he was not cross-examined.
He has not.
withdrawn, man.
So his
It was.
It was withdrawn, man.
Now your Lordship may please to peruse the findings or reasons given by the learned trial. Hmm? 22, page 20. Factual parts I am skipping, Lordship. Well, Lordship, me please to come to page 31. Page 31, para 14. Honorable Supreme Court of India has earlier in the year 1958 in so and so and so and so, reported in so and so, observed as follows. What is the true legal position of the matter of proof of wills? It is well settled that the proof of the will presents a recurring topic for the decision in courts, and there are large number of judicial pronouncements on the subject. The party propounding a will or otherwise making a claim under a will is no doubt seeking to prove a document and is deciding how it is to be governed. We must inevitably refer to the statutory provisions which govern the proof of the document. Section 67 and 68 of the Evidence Act are relevant for this purpose. Under Section 67, if a document is alleged to be signed by any person, the signature of the said person must be proved to be in his handwriting, and for proving such a handwriting under Section 45 and 47 of the Act, the opinion of the expert and of persons acquainted with the handwriting of the person concerned are made relevant. Section 68 deal with the proof of the execution of the execution of the propounder's case that the signature in question is the signature of the testator may not remove the doubt created by the appearance of the signature. The condition
No,
of
no.
the testator mind may
No.
appear to be very,
You have missed one page, complete page.
yes.
From 31, you have jumped to 33.
Really? Page 100. Oh, sorry. Document required by law to be attested, and it proves that such a document shall not be used as evidence until one attesting witnesses at least has been called for the parties by proving its execution. So one attesting witness is examined, that is sufficient. These provisions prescribe the requirements and the nature of the proof which must be satisfied by the party who relies on a document in a court of law. Similarly, Section 59 and 63 of the Indian Succession Act are also relevant. Section 59 provides that every person of the sound mind, not being a minor, may dispose of his property by will, and the 3 illustration to the section indicates what is meant by the expression a person of sound mind. In the context, Section 63 requires that the testator shall sign or affix his mark to the will, or it shall be signed by some other persons in his presence and by the direction, and that the signature or mark shall be show made that it shall appear that it was intended thereby to give effect to the writing of a will. The section also requires that the will shall be attested by 2 or more witnesses as prescribed. Thus, the question as to the whether the will set up by the propounder is proved to be the last will of the testator has to be decided in the light of the provisions. Has the testator signed the will? Did he understand the nature and effect of the disposition of the will? Did he put his signature in the will knowing that it concerns stated broadly? It is the decision of these questions which determine the nature of the finding or on the question of the proof of the will. If word prima facie to be true, say that the will has to be proved like any other document except as to the special requirement of attesting for attesting by Section 63 of the Indian Section, as in the case of the proof of other documents. So in the case of proof of writing wills, it would be the exact proof with mathematics. It would be the idle to expect proof with the mathematical certainty. The test to be applied would by the usual test of the satisfaction of the prudent mind in such matters. Then your lordship may come to page lordship 34, para 15, last para. On going through the aforesaid judgment of the Honorable Supreme Court as well as the Honorable Gauhati High Court reveals that the propounder of the will to get probate shall prove that will as per the provisions of Section 63 of the Indian Succession Act and 25 Section 63 of the Indian Succession Act provides as follows. Then the section is quoted. Lordship, every testator not being a soldier implied a reason, they are proof A, the testator shall sign or shall affix his mark to the will, or it shall be signed by some other person in his presence and by his direction. B, the signature or mark of the testator or the signature of the person signing for him shall be so stated that it shall appear that it was intended thereby to give effect to the writing of the will. C, The will shall be attested by two or more regarding the attestation. I'm skipping it, Lordship. Then your Lordship may come to para 70, bottom para. PW1 Virendranath Phukan is the petitioner of this case. PW1 in his examination in chief and affidavit reiterated the statements made in the petition. From the evidence of PW1, it reveals that it is the youngest, that he is the youngest brother of the deceased late Nipendranath Phukan and the OP Devendranath Phukan. From evidence, it also reveals that Devendranath Phukan filed a that the Devendranath Phukan had filed a suit for partition against the petition and also filed a partition case. And while he prepared objection for the partition case, but found that the will or testament of the late Nipendranath Phukan was executed in his favor. To prove the will, the petitioner examined PW2 Minal Das, and who is one of the attesting witnesses of the will PW2. In his examination, chief stated that he was present at the time of execution of the will and testament by Nipendranath, and show the said testator affixing his signature thereto, that the said testator acknowledges the said writing in his last will and testator and in his presence. He proved the signature of the testator Nipendranath Phukan as Exhibit 1 and Exhibit 1(4) is his signature. He in his evidence also stated that at the time of execution of the will, the executor testator was a sound state of mind and signed the said will in presence of him and other attesting witnesses, namely Sri Rajendra Kumar Sharma and Siddhartha Datta. Though the OP defendant examined himself but could not able to impeach the veracity of the evidence of PW3 Sri Siddhartha Datta is also one of the attesting witnesses. PW3 is in his evidence stated that the deceased Nipendranath Phukan executed his last will and testator on 20th of March 2009 in his presence, and he was one of the attesting witnesses of the said will. PW3 in his evidence further stated that he was present at the time of execution of the last will and testament by Nipendranath Phukan, and so the said testator affixing the signature thereto, and the said testator acknowledges the said writing in his last will and testament, and is in his presence. He also proved the signature of late Nipendranath Phukan, testator exhibit 1/1. He is in his evidence also stated that said Nipendranath Phukan, testator at that time of the execution of the will was in sound state of mind, and he signed the said will in presence of him and other two attesting witnesses, namely Sri Rajendra Kumar Sharma and Mrinal Das, and his out of his free will and volition, without being influenced by any portion or inducement from any corner. Though the defense side cross though the defense side cross examination PW3 could not be able to impeach his veracity of the and the evidence except but some suggestions. Then Lordship para 19 bottom, that the evidence of the PW2 and 3, it appears that they in their examination in chief stated that at the time of execution of the will, PW2 and 3 and 1 Rajendra Kumar Sharma were present. On going through the exhibit 1, it reveals that Rajendra Kumar Sharma was the scribe of the will. So it appears that at the time of execution of the will, there were 3 persons. Learned advocate of the defendant submitted that during cross-examination of PW2 and 3, they stated that there are 3 attesting witnesses, but from their examination in chief, it reveals that there are 2 attesting witnesses. As such, their evidence is not billable. Para 20. Para 20. I have gone through the exhibit evidence of the PW2, 3, and it reveals that at the time of examination of the will, there were 3 persons, that is PW2, 3, PW2, 3, and 1 Rajendra Kumar Sharma. So I found that there is no doubt that at the time of execution of the will, 3 persons will there were 3 persons beyond the execution of the beyond execution of the. So these evidences as beyond doubt regarding execution of the will, exhibit 1, I find no force in the submission of the learned advocate for the defendant. Learned advocate of the defendant further submitted that exhibit 1, there was marked as thumb impression mark, but PW2 and 3 in their evidence stated that this is Nipendranath Phukan put his signature in their presence, which is contrary to the said will, as the evidence of PW2 and 3 are not available, and these evidences are suspicious. Para 21. On going through the evidences on record, it reveals that the DW1, that is the OP of this case, due to DW1 during his cross-examination clearly stated that he does not dispute the signature of the deceased Nipendranath Phukan, exhibit 1, and he had not seen signatures be forcibly taken from late Nipendra Narayan Phukan, exhibit 1. So it appears that the thumb impression or signatures, whatever it may be, that is exhibit 1, not disputed by the defendant. Moreover, on going through the exhibit 1, it reveals that there is signature as well as thumb impression of the testator. Para 22, that the OP defendant in the written objection taken several issues, such as the petitioner forcibly by inducement taken the signature of late Nipendranath Phukan in the will, and at the time of execution of the will, Nipendranath Phukan was not in a sound state of mind. But from the evidences of PW2 and 3, it reveals that at the time of execution of the will, late Nipendranath Phukan was in sound state of mind. Moreover, from the evidence of DW2 and 3, it reveals that till the death of late Nipendranath Phukan, he was working as a resident director of Bahini Tea Estate. So from their evidence, it is revealed that he was in sound state of mind at the time of execution of the will. PW2 and 3 in the evidence clearly stated that at the time of execution of the will, testator was Nipendranath Phukan was in sound mind state, sound state of mind. To disprove the evidences of PW2 and 3, the defendant side could not able to produce any document to show that at the time of execution of the will, the deceased Nipendranath Phukan was not in a sound state of mind. So from the entire evidence on record, it reveals that as per the provisions of Section 63 of the Indian Succession Act, the petitioner able to prove the execution and the genuineness of the will executed by testator Nipendranath Phukan, and there is no any suspicion in the circumstances of the execution of the will, and ultimately the probate was granted. Here, Lordship, the appellant defendant has submitted that Nipendranath Phukan was not in a sound mind and good health, and he was not able to take the decision out. But not a medical, nothing, no medical document relating to Nipendra Fukan has been filed in a lordship. Nothing has been proved. And allegation is that his signature was manufactured or forged lordship, but the signatures which are appearing over the will, but no petition was filed by the appellant defendant to send the specimen signatures to the FSL lordship. That was the duty. The burden lied upon the defendant to get the signatures verified through the FSL. That has not been done, your lords. Even the Supreme Court decision I have quoted in the improving judgment, lordship says that handwriting experts would have been consulted and called.
Okay.
So my humble submission is this entire case. Everything, lordship, in a will case, will case, probate case, lordship. Once the defendant agreed that it is the signature of the executor, your honor, and then only burden lies upon the petitioner to examine the at least one attesting witnesses. Here, lordship, two attesting witnesses have been examined. So my humble submission is this, lordship, there is no merit in the case and it is liable to be dismissed, lordship.
Stand up, stand up.
These are my-
Sir. Dismiss with cost.
Any reply?
Well, two judgments which my learned friend has relied upon regarding 2011, that Mira Bora case and Matadin Mo. Two cases, that is on verification. No way connected with the case in hand.
No, he has also,
Verification, I'll come to that.
he has questioned your verification also.
Yes, but that is not in judgment, it's not in discussions.
Okay.
And your lordship, I have shown the judgment of this court, apex court, that it is the consciousness of the court to see whether this will has been done in a proper manner. If the court is satisfied, then only the probate can be done.
No, but
Satisfied.
you did not ask any question regarding squeezing of handwriting,
Hello?
regarding squeezing of writing in the will.
Case of it shows my lord.
Yes, but you have not asked any question to any of the witnesses
I'll
as to why it happened.
that writer of the will is not there before the court. Writer of the will is not there, and two judgments. First, let me just finish the two judgments which are provided under Mira Bora case and Matadin. No way connected with the case because this is a case relating to verification and no decision of the learned trial judge regarding the finding fault with the verification. And second case which my learned friend has relied upon is Deepak Deka case. Yeah, for that matter, I would submit, my lord. भाई साहब बैठे ना बोलना है तकलीफ होता है Deepak Deka case, it's a totally different facts and circumstances case. I'll just show this. Paragraph 4, your lordship take into consideration. Deepak Deka case.
Yes.
Totally different facts, my lord. This fact is different in the other case, and the case which is before this court is totally different. Deepak Deka. The two cases which I have shown that relating to verification is not connected at all. Deepak Deka case, your lordship will kindly see paragraph 4. Next page, your lordship will see. Which has been quoted as regard by the defense taken in the case. So that is going to show that this case and the case before your lordship is totally different. I'll read next page, paragraph 5, which has been quoted from the written objections. May I just read that one?
Yes.
In the said written objection, various preliminary objections were taken as regard the non-maintainability of the said probate proceedings. On merits, it was stated that late Niroda Deka had not left any will or testator in favor of the mala fide beneficiaries
and or in favor of the plaintiff as are executed in any manner, and has the question of grant of probate certificate by the court in favor of the plaintiff did not arise at all. It was further stated that the alleged will is not a registered instrument document as per the requirement of the Registration Act as it relates to immovable property. Value of the said is more than 100. This is not our case, and hence the same is liable to be dismissed or rejected. In paragraph 11, which is the reply to the statements made in paragraph so and so of the probate application, the defendant stated that alleged will is not executed and left behind by the deceased Nirodha Deka, and the same is forged, manufactured, and got up document of the illegal beneficiary, and the petitioner made out taking the advantage of the helpless conditions of the answering defendants. So our fact is totally different. Paragraph 7, your lordship will kindly see the findings. The record further reveals that on so and so the plaintiff filed evidence on affidavit of four plaintiff witnesses and exhibited various documents. Thereafter, it appears from the perusal of the order dated so and so that the said probate title suit number so and so was registered as probate title suit number so and so. It further appears that the defendant adduced the evidence of two witnesses who were defendant number 1, Sri Deka, and 1, Sri Dayamanti Das, who was the defendant witness number 2. The witnesses, upon being cross-examined, the trial court by judgment dated decreed their probate. In doing so, the trial court held that a petition for probate filed by the petitioner was maintainable. While deciding the issue number 2, the trial court taking into account the various evidence led as well as the propositions of law relating to the grant of probate, came to a finding that the plaintiff had succeeded in establishing the cogent evidence that the testatrix had affixed her thumb impression on so and so as per her own volition on so and so at Gauhati, having understood the nature and effect of the disposition. This is not in their evidence regarding, my lord, understanding of who has read out the will to him, whether he understood or not. This is very important. This has not been this totally different facts, my lord. So therefore, I submit, my lord, the facts relied upon by my learned friend in 2022 6 GLT is totally different facts and circumstantial case, and not at all. It doesn't match the present appeal in any circumstances. And regarding this, my lord, your lordship will kindly see page 65. 86, your lordship has already noted. I'll just point out page 65. I'm just reiterating, and your lordship has, although your lordship has noted, to point out this is PW1. He says, well, I do not know where the will was executed.
Yes.
By my brother. And what PW3 has said at page 86, your lordship has read, my lord, that it was done in the house of Birendranath Kumar. So I'll just point out this page 32, the judgment quoted. I have read, I think, this judgment. I'll just again point out a particular paragraph. Relevant is at page 32, after about 10 paragraphs. Yeah. Does the question, may I just say?
Yes.
Important is this, my lord. Does the question as to whether the will set up by the propounder, has your lordship got it, my lord?
Yes.
After about 10 sentences, does the question, right hand side, does the question as to whether the will set up by the proprietor, the propounder, is proved to be the last will of the testator has to be decided in the light of this provision. Has the testator signed a will? Did he understand the nature and effect of the dispositions in the will? Did he put his signatures to the will knowing what it contained? There is no evidence to that effect. Even if your lordship accepts that the signature is correct, it can be accepted, my lord. Whether the contents, my lord, who has read out the contents to him? Did he understand that? This question is relevant, and subsequently also, my lord, on this itself, my lord, this will goes, judgment goes. The learned judge has recorded all these judgments, but he has not looked into the evidentiary value of the witnesses. My lord. Page 35, section 63, B, my lord. Has your lordship got it? No? Page
Yes.
35.
Yes.
B. The signature or mark of the testator, has your lordship got it? No?
Yes.
Yes, signature or mark of the testator or the signature of the person signed by for him shall be so placed that it shall appear that it was intended thereby to give effect to the writing of the will. These are done only taking into consideration that there may be persons who will just take the signature and make the will. To safeguard this, this kind of, my lord, fraud, my lord, I must say this kind of provisions has been provided. Now I'll just provide only one judgment before this court. I'll conclude my, yeah, 2015. 2015 12 SCC. My lord, both trial, my lord, probate was there and the title suit was also there. Trial court, my lord, dismissed the suit and allowed the trial, allowed the probate. Paragraph 7. Paragraph 7. May I just say?
Yes.
The trial court dismissed the civil suit, holding that the will executed by so-and-so in the year 1977 in favor of so-and-so is legal, and the sale effected by her during the pendency of the civil suit is in favor of defendant number 5 is also legal and valid. The trial judge recorded the finding that the Sumitra Bai had not perfected her title by adverse possession and the plaintiff could not establish that Full Bai was a concubine of late so-and-so. The trial court also recorded a finding that the plaintiff failed to establish that the will was a fraudulent and a fabricated document. So paragraph, my lord, 17. So this is while overturning the judgment passed by the learned trial court, this is the judgment quoted, relevant portion of the judgment quoted by the High Court. Paragraph 17. If we apply the above law, this Ganesh Ram case, my lord, law in the present matter, it would appear that the attesting witnesses were not examined because they were not alive, and will has been proved by only examining the scribe, SPW3. Though it has been stated by the scribe that he has drafted and typed the will on the instructions of the testatrix, but this fact appears to be false on the face of the document itself. There are many suspicious circumstances appearing on the face of document which go to suggest that in fact nothing was drafted or typed by the scribe on the instructions of the testatrix, but a typed matter was placed before him for getting it registered, showing as the will of the testatrix. First of all, it would appear that though the will has ended in a very second sheet, but there is no space left for signature of the scribe, and the scribe has inserted his signature in between the last two lines by using an ink pen. Secondly, it appears that the complete date, like 18/8/77, was not typed in the second page and only on 8/1977 was typed, and figures like 18 have been inserted by an ink pen, showing as the document was executed on 18/8/77. So your lordship will kindly see if it shows the suspicious circumstances under which the will was drawn, my lord. It doesn't, in the present case, my lord, it was not shown that somebody has seen the explained to the late Nipendranath Fukan as regard the contents of the will. And your lordship, on the face of the record itself, will itself, it shows that the it's a fraudulent one because the signatures differs and it has been squeezed. There is no reason for that. There is no dearth of paper. It is because of dearth of, nobody has stated that there is because of dearth of paper we have done this. Paragraph 18, my lord. Paragraph 18. No. It is evident from the findings recorded by the High Court in the paragraph referred to herein above that the will suffers from serious suspicious circumstances. The execution of a document does not mean mechanical act of signing the document or getting it signed, but an intelligent appreciation of the contents of the document and signing it in token of acceptance of those contents. Proof of a will stands in a higher degree in comparison to other documents. There must be a clear evidence of the attesting witnesses or other witnesses that the contents of the will were read over to the executant, and he, after admitting the same to be correct, puts his signature in presence of the witnesses. The evidence doesn't show this, my lord. Completely in foul of this, my lord, proposition of law. There is no evidence showing that the Nipendranath Phukan has understood the will. He has signed the will as per after understanding of the will. In fact, my lord, the document itself shows it's a fraudulent document. It has been manufactured one. It is only after the executant puts his signature, the attesting witnesses shall put their signature in the presence of the executant. In the instant case, the suspicious circumstances appear to be that when the will was being executed, the thumb impressions over the alleged will was also taken by the beneficiaries, and the document writer was shown to be scribe of the document, whereas the document was not scribed by him. However, late so and so filed written statement before her death, but she did not whisper anything about the will in the written statement. Admittedly, the will was allegedly executed in 77, whereas the written statement was signed and so. So therefore, this requirement of law that he has to understand the contents of the document which has to be read out to him, this is completely lacking in the evidences adduced by the PWs in the present case. So besides my lord, the suspicious circumstances under which the will was drawn and written, my lord, as has been shown by which is reflectable on the basis of the will itself. My lord, the other proposition that the will was not, the contents of the same was not read out to late Nipendranath Phukan, and that the contents is as per his dictation. That is completely lacking in the present case. So on this ground itself, my lord, the impugned judgment is liable to be set aside in court. Mul submission.
Third, Mr. B.D. Das, the learned senior counsel, assisted by Mr. H.K. Sharma, the learned counsel for the appellant. Also heard Mr. S.V. Roy. Hearing concluded, judgment reserved. Judgment reserved.
Your lordship will note the whole property of the family is in the will. No, that I've already shown. Deeply obliged.
Obliged.
No, Mr. Das. Whole property or only the property of Nipendra?
Yes.
Nipendranath,
Whole
family property. That is.
His share,
Lordship.
His share only.
He obtained a separate patta by partition, lordship.
Jorat property, Jorat shares.
Only his share.
The
one
share
third
that
share.
Nipendranath property means Jorat whole property, madam.
Yes.
And here also the whole property. He is in possession. Three brothers are there. He is in possession.
He
Even now.
filed many suits, cases, lordship, against Nipendra.
No,
Nath Phukan.
that's
Defendant
a
appellant,
mutation
lordship.
case. He has to be a party.
Why he should give to such a person?
Madam, your lordship has
Natural thing you have to lordship.
I have heard both of you at length.
Obliged.
Yes, Mr. Majumdar.
My lord,
In other two review petitions,
my lord.
their grounds are that in respect of 85 lakhs,
My lord.
30% solatium.
My lord,
was-
that I have submitted in the morning hours. Your lordship may possibly first decide the two appeals
Yes,
filed by the
yes.
collector.
Suppose
Based on that,
if his review is allowed, then this will not stand. But if your review is dismissed,
yes, then
then
lordship,
what is your submission?
my lord, if my review, if your lordship is hearing both at a time, my lord.
Yes.
Possibly, my lord, if your lordship dismisses my review, our review applications, then naturally they will be entitled on the additional amount.
Okay. Okay, then
Or lordship may decide simultaneously, or lordship may first decide the two appeals filed by the state. And after that, possibly lordship may take it up. Or
no, we can dispose of, even if we have to dismiss
Yes.
two reviews.
Yes.
Two reviews may be allowed, two will be dismissed.
yes.
Out of 4. Heard Mr. S. Deka, the learned counsel for review petitioner. It is in review petition number 285
And 286.
and 286. Learned counsel for the review petitioner. Also heard Mr. D. Majumdar, the learned additional Advocate General, assisted by Miss D. D. Das, learned additional senior government counsel, appearing for the state responding, as well as Mr. M. Nath, the learned senior counsel, assisted by Mr. A. Bhattacharjee, appearing for respondent number 2. Yes. Hearing concluded, judgment reserved.
Leave government.
Celia is on legs, should I maybe pass out for the time?
After something. Yes. Yes.
Item number 12, can we pass off for the time being?
There was a talk of compromise, whether any compromise has been reached.
He was there,
Who?
So, Mr. Subham Datta.
Actually, my colleague, I'll just call in.
Okay, we'll take it up after some time.
Amresh.
Mr. Mondal is there for respondent.
No, he's not there.
They're not there. So Lordship will give a date, I suppose. I do not know.
Miss R.D. Majumdar, the learned counsel for the appellant. None is present for the respondent. Hence, let this matter be listed after 3 weeks on a date to be fixed by registrar.
Hello, pleasure. 4 weeks, Lordship.
After
Third
4
week I will not.
After 4 weeks.
Hello, pleasure.
Item 19. Item 19.
I am appellant lordship here.
What to do, adjourn?
Lordship, we can wait because I want to do from morning if not even one
No,
case.
but
is-
then it has to go ex parte.
Oh, no, they are appearing, lordship.
Then we'll wait for some time.
Yes, lordship.
Mr. S. Dr. Award silence, my lord. Grounds, simple three grounds have been set, mentioned, my lord. Case, my lord, that is three. It was death case, my lord. That was the case of Mr. Jyotish Das' wife expired, who was the MLA in Golpara, my lord. Net accident, my lord. On Golpara
But
district.
counsel-
Some claim,
Appellant is not there.
yes, my lord. Yes, doctor.
He's in another courtroom.
We'll take it up.
Waiting.
Yes.
May I please, my lord? My lord, on the last occasion, they have objected regarding the maintainability of a single appeal.
Yes.
But in this case, my lord, the decree for the dismissal of the suit was not prepared. There is only one decree, and that is in favor of the allowing the counterclaim. If your lordship may see the page number 46.
Appeal song.
Forty-six in my memo of appeal.
Appeal is ready for hearing.
No, your lordship, actually the IA was fixed for hearing.
No,
The entire RFA has to be heard. Otherwise, the matter will not be complete. Because if they want vacation of this day, so the entire appeal has to be heard for that.
No, not vacation of the state.
No, they won't stay.
Yes.
They want to stay, yes, yes.
Then we'll stay the execution and hear.
One point which I want to reflect is that the counterclaim is regarding land measuring 2 Katha 8 Lecture, and that is for specific performance of contract, and that has already been executed. Now what remains?
No,
I have
only sale deed has been executed.
Yes.
Possession has not
Yes.
been handed over.
But
They are
yes.
praying for this halt to that part of execution, handing over possession. That part will stay.
Yes, my lord.
But your lordship, there is a decision of the apex court also that the execution proceedings that has to be completed within 6 months. So this execution case was filed in the year 2020.
Okay, whether are you ready for final
I am
hearing?
ready for
Final hearing.
Will not take much time.
RFA, you are ready?
Actually, lordship, I am not ready for the final hearing because today is the date fixed for hearing on the IA.
No.
I'll just show the loopholes, your lordship. Will not take much time.
The matter is fixed for final hearing today.
Because the
How much time will you take? How much time?
So actually,
When will you be ready?
And regarding the maintainability, the lordship will find page 35. There are 2 decrees here.
final hearing of the motion. Your lordship, if they are ready, then I will
Monday
also
or
put my
Tuesday?
arguments.
But you are not ready.
Today I am not ready because I was
Then-
under the impression that
No, then come,
IAS will be heard first.
come prepared. We'll fixing it, giving a short date.
On
T-
Tuesday.
No, not on Tuesday. till that day,
Yes, my lord, till
remaining
that,
part will be stayed.
only the part of the possession may not be handled.
Heard Mr. C. Sharma, the learned counsel for the appellant. Also heard Mr. S. Datta in main appeal. S. Datta, the learned counsel for the respondent, who submits that he is ready for hearing. However, learned counsel for the appellants submits that he has come prepared only to argue the interlocutory application and needs some time to make his submission in the instant regular first appeal, and therefore he prays for an adjournment. Stop. Considering the submissions made by learned counsel for both sides, the prayer for adjournment is allowed at a short date. 7th of August. List this matter on 7th of August. In IA, heard Mr. C. Sharma, learned counsel for the applicant. Also heard Mr. S. Datta, the learned counsel for the respondent. This application under section 41, under order 41, rule 5 of the Code of Civil Procedure 1908 has been filed in connection with the regular first appeal number 7/2023, praying for stay of execution of the impugned judgment and decree during the pendency of the connected regular first appeal. Learned counsel for the applicant has submitted that the connected appeal has been listed for final hearing on 7th of August. And in the meanwhile, part of the decree relating to the execution of the sale deed has already been executed. He, however, submits that the applicant is still in possession of the decretal land, and unless a stay is granted, he may be evicted therefrom, and may be evicted therefrom before the decision of the connected appeal. And as such, he submits that unless stay is granted, the connected appeal would become infructuous. On the other hand, learned counsel for the opposite party submits that the decree has already been executed and only the possession of the decretal land has to be handed over. A decree has already been executed in as much as sale deed in pursuant to the decree has been executed. After considering the submissions made by learned counsel for both sides, it appears that since the applicant is claiming that he is in possession of the decretal land, and since the connected appeal has been fixed for final hearing on 7th of August, the further proceeding of execution case number further execution of the impugned judgment and decree shall remain stayed during the pendency of the connected regular first appeal. This interlocutory application is accordingly disposed.
Obliged, deeply obliged.
No. No one is there, Lordship. After 4 weeks, Lordship.
Heard Ms. R.D. Majumdar, learned counsel for the respondent in MSC case number.
I'm appellant, Lordship.
In 22, you are appellant.
Yes. In 21, I'm responding.
Respondent in MSC appeal number 290/2022, as well as appellant in MAC appeal number 484/2022. None has appeared for the other side. Hence, this matter is adjourned. List this matter after 4 weeks on a date to be fixed by registry.
Your Lordship, 19 also. Koribani? Yes, yeah, correct.
Item number 19.
My senior, he is coming on next on other courts.
Okay, let him come.
Let him come. Otherwise, maybe we cannot finish also.
Yes.
Item 23. Fifth 21, Lordship.
Yes. 21 after 4 weeks.
Chief.
21, you are ready?
I'm ready.
Lordship.
Whether we can finish because dear Lordship.
I need to 5 minutes, 5 to 10 minutes.
I'll need more.
No, I don't believe you.
Yes.
No, Lordship, in item number 21, Lordship, just my enhancement, Lordship. So,
Date at the due. After 4 weeks.
Lordship, if possible, Lordship, today, Lordship.
No, other side is saying that it will go long.
It will take time. because
It will take
they're
time.
Saying that I'll show many documents.
8 September. 8 September.
Lordship, hello.
Item 23.
'23. None has appeared for the appellant on call. Mr. S.I. Akan, appearing for respondent number 1. Let this matter be listed after 4 weeks.
Lordship, that means this otherwise it will be again mentioned for orders.
10 November.
So. Litigant 19.
Yes.
Lordship, our here, Lordship, it is basically on quantum. We are challenging the quantum because the tribunal has given taken the income to be 10,000, whereas it was specific evidence of the claimant that she was getting 2,400. And
2,400.
yes, she was working. I'll show that, Lordship, from their evidence itself, Lordship. And in fact, in the first claim petition, they had said the income to be 600 rupees
600 per month.
per month. Because she was working in a hospital, I suppose. Or then they amended the petition, Lordship. Lordship will find that that amendment petition was filed on 22/9/16, and thereby they said from 600 income, they said 5,400, but in evidence again they said she got 2,400.
How much court took?
10,000.
Okay.
Whereas there was specific evidence that she was getting.
Yes, apart from this, any other ground?
Yes, Lordship. Then, Lordship, from the judgment. Uh, Then Lordship, the amount given loss of marriage prospect, that amount is 5 lakh something, Lordship. 5 lakhs, then pain and all the compensation amount, Lordship, are on the higher side. And one of the ground we have taken is that the case was filed in 2009, but only in 2017 the evidence was adduced, Lordship. And Lordship, the tribunal came to the findings, Lordship, based on photocopies, Lordship. Lordship, from the trial court, Lordship, the amended petition at para 3, Lordship, that is at page 43, Lordship. She said the income to be, that Lordship is at page 45. Amended petition starts at 43, 45 is the relevant, then where she says that she used to get 2,400. Then Lordship, in the amended petition, she said 5,400. Then Lordship, let's come to evidence of Mangal Koiri, father, at page 82 of the LCR, Lordship.
NCR. NCR. No. First file to
89 is Tarabati Koiri. The mother of the injured. And 93 is claimant herself, Lordship. Tarabati Koiri, Lordship, will find they have themselves mentioned Xerox copy of all the documents, Lordship, we'll see. All Xerox copy, and in the cross examination that objection was taken. Mangal Koiri also Xerox copies objection taken. And for Tarabati Koiri, in her evidence itself, she has mentioned all the documents to be Xerox copies. And they were objected to. And for the claimant herself, Lordship, claimant's evidence, Lordship, page 93. Lordship, claimant's evidence, cross Lordship, as page 98 in bracket 2. Where I'll show that the income, Lordship, 2,400 she has. Lordship, got it? Page 98 in bracket Roman 2.
Yes.
Lordship, cross-examination. In my examination in chief, I have asserted in para number 2 that I am employed as nurse in Valley Hospital, where I was getting fixed salary of 2,400 per month, Lordship. It is her own evidence, Lordship. When in evidence something is coming, Lordship, the court cannot on its own decide that she was getting 10,000 rupees. I have shown examination, those are all yet. Then Lordship, next para. Lordship, about the Xerox copies.
This is less than even minimum wages.
That is true, Lordship, but since they are asserting that, Lordship, when once they are asserting in that situation, Lordship, minimum wages will not come when they are saying themselves. And they got an opportunity, they amended their petition, because earlier it was written, if Lordship goes through their claim petition, the original claim petition, it is only 600, the copy which was served to us. Lordship, then the next paragraph, Lordship, about the
600, then from 600, they amended it to,
5,400.
and then there in a.
In
there-
evidence, she is saying she used to get 2,400,
And the court assessed at 10,000.
10,000. That is too high, Lordship. I'll again read, Lordship, after that, Lordship. I have sworn examination in chief on affidavit before the notary on 17/6/2016, and in the said affidavit, I was identified by my lawyer, Asharani Dusat. I have not received, Lordship, this will be important. I have not, because court has gone into a finding that she had received one appointment letter from, and she would have been appointed. I'll read the judgment part for that, Lordship. I'm showing the evidence first. I have not received any appointment letter from any authority. Neither I got information regarding salary payable to me from the department concerned. It is not a fact that I have not submitted any documentary proof to show that I am still continuing treatment at home under instruction of doctor of CMC. Disability certificate was issued by Dr. A.P. Sipani. My initial treatment was at GMCS. Thereafter, I conducted treatment in GNRC and CMC. Before GMCH, I was treated at Shillong Civil Hospital. Then, Lordship, all the exhibits are Xerox copy, and these are duly objected to by the insurance company, Lordship. All Xerox copy except for, Lordship, the FIR charge sheet I've written somewhere. FIR charge sheet, the seizure list, except for that, all medical documents are Xerox copies, Lordship. And that is why for all the other year also, we have objected to that with the other witnesses also.
Okay.
Certified copies are, Lordship, Exhibit 1, that is Form 54, Exhibit 2, 3, 4, 5, 6, 7. Other than that, Exhibit 2 is also photocopy, Lordship. So these were objected to. Then, Lordship, will come to the examination of Chief of Mongol Query. His father, and his examination in chief affidavit starts at page 98, I suppose, Lordship.
Yes.
Paragraph 3, Lordship.
'98.
98 his am I wrong, Lordship?
No, there is no paragraphing.
Oh, para 1, Lordship, got it. He has started with affidavit I Sri Mongol Koiri.
Oh, cross-exam.
Cross is 98. Yes, Lordship is
Cross is-
correct. Mongol Koiri 82, Lordship. Chief is at 82. Sorry.
Yes. Yes.
Lordship will turn 3 pages. Lordship will come to paragraph 3. Here he has mentioned about the income, Lordship. Before paragraph 3, Lordship. After 3 pages, Lordship. Before meeting with the fateful accident of as aforesaid, my said daughter was serving as ANM at Valley Hospital, Meherpur, Silchar 15, and her income from all sources by then was rupees 5,400, Lordship. So he is giving another amount from all sources. She said about her income from other sources they have not proved, Lordship. The claimant herself said that she was getting 2,400 as a fixed amount from the hospital. In Mongol Koiri's cross also, Lordship, we did bring it out that they Lordship, here, Lordship, in his cross-examination of Mongol Koiri, Lordship, page 98, he at line 1, 2, 3, 4, 5, 6, 7, 8. The incident took place, Lordship, got the page?
Yes.
After 8-line, Lordship, Annexer 1, the prominent part is Annexer 1 was obtained by me from the Valley Hospital and Research Center, wherein the monthly salary is shown as 2,400. The contract period of service was 5 years. If I read the whole cross, Lordship, their compensation will be reduced tremendously. Already we have deposited 50%, but the court has allowed them to withdraw 7 lakh something, Lordship. 7,25,760. Rest of the amount is there. Because firstly, Lordship, that these are Xerox, and it was those documents are all Xerox.
Okay, what
They-
was the reasoning of the court?
Lordship, yes. Now I'll go through. Decision and reasons thereof, Lordship. Internal place 3 and my memo of appeal 6, Lordship. 8, Lordship.
Yes.
A claim before the Motor Accident Claims Tribunal is neither a criminal case nor a civil case. In a criminal case, the matter is to be proved beyond all reasonable doubt, and in a civil case, the matter is to be proved on the basis of preponderance of evidence. But the standard of proof is much below than what is required in a criminal case as well as in a civil case. There should be some material before the tribunal on the basis of which the tribunal may arrive or decide things necessary to be decided for awarding compensation. The tribunal should have a broad view of the whole matter as observed in Ranubala Paul versus Bani Chakrabarti, 1998, so and so. In the instant case, claimant is claiming that she met the accident while she was traveling in the ASTC bus from Gauhati to Silchar. She deposed on oath and nothing adverse could be elicited from her cross-examination. And moreover, after perusal of the case record meticulously, I have found FIR charge sheet, seizure list, etc. prepared by police, which is the prime investigating agency of the accident. Therefore, this court can rely on the documentary evidence produced by claimant. On perusal of the FIR and charge sheet, this court has come into a conclusion that in connection with the accident took place on 31/2008, Madan Riting PS GD number so and so dated so and so was made on Madan Riting PS case number so and so under section so and so IPC was registered. The final report charge sheet report revealed that during course of investigation a prima facie case under section so and so IPC IC was found well established against driver of the ASTC bus bearing number so and so, namely Debo Kanto Deka. Therefore, it has been established that claimant met the accident due to rash and negligent driving of the driver of the ASTC bus. Exhibit 6 is the discharge slip of Shillong Civil Hospital, which reveals that claimant was admitted on the date of accident was on discharge on the following date. Exhibit 7 is the disability certificate issued by SMCH exhibited by Mongol Koiri. It reveals that claimant was issued the disability certificate from Department of Orthopedics certifying permanent physical impairment of 100%. It is also certified that the condition is non-progressive and not likely to improve. Reassessment was also not recommended. The contesting OP could not bring any material on to record to discard the disability certificate relied on by claimant. Moreover, claimant has been certified to be a patient of disability in relation to both lower limbs, and therefore the Department of Orthopedics is enough to issue the disability certificate. Accordingly, on the basis of the documentary evidence, this court, in absence of any other adverse evidence from the contesting OP, is of opinion that the accident occurred due to rash and negligent driving, and the claimant has become permanently disabled due to sustaining injuries in the motor accident. These issues are decided accordingly in favor of the claimant. Issue number 3 and 4. Claimant also appeared before this tribunal various times. She could not move without wheelchair. Moreover, she has been certified as a permanently disabled person to the extent of 100% in relation to her both lower limbs. Therefore, she is entitled to compensation under various heads as discussed herein below. Exhibit 1, marked by claimant herself, revealed that she completed 1.5-year course of female health worker from Assam Nurse Midwives and Health Visitors Council, Gauhati, Assam, and passed the final examination on 17 November 2006. Exhibit 1-2 also reveals that she is graduate from Assam University. Exhibit 2 is the call letter from National Rural Health Mission by which she was called for an interview for the post of ANM on 29/1/2008. Therefore, it has been established that claimant was a nurse and was eligible to be appointed as an ANM. Accordingly, considering the physical permanent disability of the claimant of 100% and occupation of claimant as nurse, this tribunal has come to a conclusion that claimant has lost her functional disability to the tune of 100%, and for this reason, she is entitled to compensation under the head of loss of earning for whole life to the extent of 100%. Lordship, without Rajkumar Ajay Kumar is very clear on this, Lordship. Without the doctor's evidence, Lordship, the treating doctor's evidence, Lordship, this cannot be accepted. 100% disability. Learned counsel for the claimant argued that had the accident been not occurred, the claimant would have been appointed as an ANM, and her salary, contractual fixed salary, would be rupees 13,000, which would also increase time to time. I have perused the necessary documents only to arrive at a just and reasonable compensation. Of course, Exhibit 6 and 9 reveals that fixed salary of an ANM is rupees 13,000. But during cross-examination, claimant deposed that she did not get any appointment letter from the authority. Lordship, this Exhibit 6-9, what they are saying, Lordship, this is also photocopy. And Lordship, this is taken in 2016, what the income is. If Lordship goes through the full record, Lordship will find all the copies are photocopies, and they have submitted that, and based on that, they are arguing that she would have been an ANM and would have been getting 13,000. And based on this, Lordship, the court, I'll read something more. But during cross-examination, claimant deposed that she did not get any appointment letter from the authority for the post of ANM. On perusal of case record also, I have not found any appointment letter in the name of claimant. But Exhibit 5 is the letter dated 9 March 2008, issued by Mission Director NRHM, Assam, conveying selection of the claimant for the post of contractual ANM under NRHM. Claimant was directed to appear before the Joint Director of Health Service and Member Secretary, Kachar District, for signing the contractual agreement. Therefore, though claimant was not appointed, but it has been established that claimant was selected and directed to join for the post. Of course, claimant did not join due to disability. These are all the court is finding on its own, Lordship.
No, it is on the basis of the Exhibit 5. Exhibit 5.
Yes, Lordship. I'll go to Exhibit 5 also then, Lordship. An injury suffered by her, but claimant was selected for the post and she would definitely earn rupees 13,000 as fixed salary. Since claimant did not earn rupees 13,000 at the time of accident, her income cannot be taken into consideration as 13,000. But Lordship, when she was not given an appointment letter, how can the court even think that she would have got 13,000? This is conjuncture only, Lordship, because the documents are all photocopies. But since she was eligible for a nurse or A&M, her possible income can be determined by the tribunal. In the case of Chandrappa versus manager Royal Sundaram Alliance so, it was observed by Appeals Court that if the amount of income made is so exorbitant or if the amount of income claimed is contrary to ground realities, the tribunal may not accept the claim of claimant and proceed to determine possible income by resorting to some guesswork prevailing to the relevant point of time. Lordship, in this, my humble submission in this particular case, Lordship, there is no need for guesswork because the claimants themselves are saying what income they are getting. They have even given the document what income they are getting. So guesswork doesn't work here. Guesswork, the court should not have gone for guesswork when there is cogent evidence, when they themselves are accepting. In the instant case, from the documents, it reveals that at the relevant point of time, salary of an A&M nurse was fixed at rupees 13,000, and therefore, as the claimant was selected for the post rupees 13,000 cannot be exorbitant. But since prior to the accident, she was not receiving the said salary, this court cannot accept the said amount as income of at the time of accident. Lordship, this sentence itself proves that whatever income she was receiving at that point of time, Lordship, that should have been yes. 13,000, Lordship, the documents, those are all photocopies. Those were taken in the year 2016. Those are RTI replies. In Lalenzami and
When the accident occurred,
accident occurred on 31/2008.
31. That means after appearing in the A&M interview on 29/1/2008. 29/1 she appeared in the interview of the A&M. Okay.
In Lalenzami and others versus so-and-so, reported in so-and-so, Gauhati. Gauhati High Court observed that considering monthly income of an unskilled worker as rupees 7,000, in Syed Siddiqui and others versus divisional so-and-so, Supreme Court observed that in absence of evidence, notional income of vegetable vendor is to be considered as rupees 6,500. In the instant case, claimant was neither a vegetable vendor nor an unskilled worker, but was a skilled worker, skilled in midwifery services, and had the qualification also to render the same. Since monthly income of a vegetable vendor is rupees 6,500 and an unskilled worker is rupees 7,000, as has observed in the aforesaid two judgments, this tribunal, comparing the skill of the claimant to those unskilled workers and vegetable vendors and keeping her skill in a higher position, has determined that at least rupees 10,000 is just and reasonable monthly income of the claimant. Therefore, Lordship, though in those cases, there was no proof that she was earning anything. In this case, the claimant herself says that she was earning 2,400 at the time of accident. So, Lordship, the court cannot compare the present case with the facts of those cases are different from the facts of our present case, Lordship. Vegetable vendor, Lordship, if I may take indulgence, Lordship, many professors who are MA, B.Ed, in private colleges earn quite less. So it can happen. But the court, when the court had evidence to that effect in cross-examination, when the amount came before the court, after that point, Lordship, the court cannot make its own guesswork. That is my humble submission, Lordship. 10,000 is just and reasonable monthly income of the claimant. Therefore, annual income in this case has been determined as rupees 1,20,000. Claimant claim her age as 21 years at the time of accident. So, Lordship, this is just the multiplier taken, Lordship. Should I read or
no?
Then, Lordship, next paragraph is on future prospect because now Lordship and 19 and 20 Lordship. Now Lordship, let me submit one thing. Rajkumar versus Ajay Kumar Lordships, Apex Court very clearly held that without the evidence of the doctor, disability cannot be accepted. Just the disability certificate will not do Lordship. The other day also I argued before Lordship, I have submitted that judgment, that the doctor has to adduce evidence, treating doctor as well as the doctor who gives, so that the insurance company has an opportunity to counter. Here the court has taken 100% as disability. That is not correct. And future prospect 40% is taken. Then Lordship, 4 lakhs, para 22 is giving 4 lakhs for medical, no, not 4, 5, court has given 5 lakhs for medical, marriage prospect. Then Lordship, 23 Lordship, 3 lakhs for pain and suffering Lordship. And Lordship, for medical expenses, 95 lakhs 220. So Lordship, total, the court came to the finding that total compensation was 40 lakh 49,520 in total. Transportation, nourishment, medical expenses.
So your main objection is income, assessment of income, then
Disability.
disability without doctor, then photostat copies of.
Photostat copies. And the amount given for marriage prospect and pain and suffering, these are also on the higher side, Lordship.
How much ought to have been given?
Lordship, loss of amenities in Rajkumar, Ajay Kumar itself, the court has said 1 lakh of rupees because this is loss of marriage prospect, loss of amenities. The 1 lakh of rupees, the court, Apex Court said, Lordship. And pain and suffering, 3 lakhs, Lordship. That I leave to Lordship. How much Lordship will give? 3 lakhs is on the higher side. And calculation of disability without the evidence of Dr. Lordship, Rajkumar, Ajay Kumar is very clear on that. So these are my main submission.
Yes.
I'll give any reply if senior gives.
So first, my lord, I'm a little handicapped without the LCM, but then, so first, my lord, the grounds taken a concern. My learned friend is
You take
basically.
the LCR if you require.
My lord, I'll just have like, because my learned friend is, my lord, basically relying upon the documents of photocopies. That's the first, my lord, thing I have to look, because that's not the ground taken in the memo appeal. In the ground of
They were already objected to.
in the
Lordship.
memo of appeal, there is not a whisper that just because the documents are photocopy, the judgment is bad. Because here, what has been the grounds are basically that she had claimed to be claiming earning rupees 2,400 and other things, my lord, that the amount on marriage prospects, etc., and disability have not been properly counted. These are the main grounds that have been taken. There not been a whisper, my lord, that this documents are photocopies and therefore they cannot be accepted.
Otherwise, what is your submission regarding?
Not very clear also, my lord, whether these were verified with the original and the photocopies were kept. But then,
No, that's why the cross to Saleh, you will get the cross in the cross. It was objected to, Lordship. It's not a question of.
because the marked as exhibits. No, presiding officer has received it, but then whether the original was produced or where is the signature is compared? But that's true. I find this to be photocopies, but then there is the principal officer, Mr. signature is the seal is there. But then I don't know whether this originals were indeed exhibited.
Whether these can be relied upon?
Exactly, but that is of course. another
Yes or
question.
no?
That's a big question, whether this can be relied upon.
The senior advocate.
But, because that being not being the ground taken also, Milad, I'm a little, that's when this to be because this just.
Under certain circumstances, even photocopies can be. You have to adduce evidence
Yes.
under section 65.
Yes.
Why secondary evidence is
Yes.
required? Whether that evidence is required, under what circumstances photocopies have to be produced.
That is there, but then Milad, I don't find anything, Milad, which was.
Or I am adjourning it, you come prepared.
Milad, that is one. My lord, because this is because I have to look into the LCR into detail, my lord.
Yes.
Because since it was not a ground taken, that's why I did not look into the LCR. Otherwise, perhaps I would look it earlier. But the grounds are totally silent on that. These are photocopies. In fact, when my learned.
We'll keep it parted. Let him come prepared.
My lord, my lord. I'll look it just now, Mil. I'll make some notes, my lord.
Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. M. Dutta, learned senior counsel, assisted by Mr. N. Udbin. Though the learned counsel for the appellant has made her submissions in this case. However, learned senior counsel for the respondent / claimant sought some time to go through the records of the MAC concern, go through the records of the MAC case number.
Yes, I'm.
1058/2009 before making his submissions and seek some time for the same. The prayer is allowed. Let this matter be listed.
Short date may be given, Lordship, otherwise we forget.
17th August.
No, Lordship, 17 to 21, I'll be not there.
After
If
20.
before that or
After 20. 27th of August.
7th of
27th
27th of
next August
August.
as part third matter.
I'll submit the judgments that day, Lordship.
Yes.
Rajkumar judgment.
Yes. List accordingly.
Well, I'll go through the records now.
I'll your place.
Deeply, sure.
May it please your lordship. Your lordship, in this matter, we have intimated the insurance company regarding the fact that the matter can be settled. And we also have the intimation letter. Now, your lordship, my learned friend was suggesting.
Who is for the claimant?
I am appearing for the claimant.
So
Suggesting that.
whether settlement has reached, it can be settled.
Yes, your lordship, it can be settled, but
So
till
try
now,
for
beg your pardon, your lordship.
try for a settlement.
Yes, your lordship.
Lordship, what happened in this case, Lordship? The judgment award was passed in the year 2017. Thereafter, they preferred the present appeal along with state petition and section 5 limitation petition. Limitation petition is allowed. Stay petition is till today pending. So I think, Lordship, if the stay is granted subject to payment of 50%, thereafter the matter is referred to the local adalat.
It can be done, your lordship.
I stay. Heard Mr. S. Dutta.
Then I can Lordship for claimant.
Yes, Dutta learned counsel for the applicant in IA number 149/2008. Also heard Mr. NI. What is the name? NI Hawk?
NI Khan Lordship.
NI Khan,
For the
learned counsel for the opposite
one A, B
parties
and C.
/ claimants. This application, this interlocutory application has been filed by the applicant, by the insurance company, praying for stay, insurance company in connection with MAC appeal number 27/2018, praying for stay of execution of the judgment and award dated 29/6/2017, passed by Motor Accident Claims Tribunal Kokrajhar in MSC case number 52/2013 during the pendency of the connected MAC appeal. It is submitted by learned counsel for the applicant that there is a possibility of the parties reaching an amicable settlement in the connected appeal. Hence, during the pendency of the appeal, the execution of the impugned judgment may be stayed. He submits that the insurance company is ready to, is agreeable to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment. Stop. Learned counsel for the claimant opposite party does not oppose the submission. In view of the submissions made by the parties, learned counsel for the parties, this interlocutory application is allowed. The execution of the impugned judgment and award dated 29/6/2017, passed in MSC case number 52/2013 by the Motor Accident Claims Tribunal Kokrajhar, is hereby stayed till during the pendency of the connected MAC appeal number 27/2018, subject to deposit of 50% of the awarded amount by the insurance company applicant before the registry of this court within 4 weeks from the date of this order. Stop. In the event of such deposit being made, the registry shall disburse the same through the. Who is the applicant? Who is the claimant?
Now the claimants are the daughter, Your Lordship,
Daughter
of the original claimant. Claimant was the mother of the deceased.
to the daughters of original claimant / opposite parties after proper verification. This interlocutory application is accordingly disposed of. In main appeal, heard Mr. S. Datta, learned counsel for the appellant, also heard Mr. N.I. Khan, learned counsel for the claimants respondents. It is submitted by learned counsel for the appellant that there is a possibility of reaching an amicable settlement between the parties and seeks some time so that same may be materialized. The prayer is allowed. Let this matter be listed after 6 weeks.
Your Lordship, it can be also fixed in the upcoming Lok Adalat.
Is it? Let this matter be listed in the ensuing Lok Adalat, scheduled to be held on 12/9. When is the Lok Adalat?
In the month of September, but exactly I don't know the.
Okay, ensuing Lok Adalat.
Then they will not make the payment. Also.
No, payment.
In the main appeal,
Much.
Item 20.
May it please allow. Your lordship, in this appeal, the grounds are not that compelling. Because one of the grounds is that interest on future prospect, which was granted. That one we are contending, and the second ground is under the head of love and affection, pain, shock and suffering. Award was granted. And also the third ground is that future prospect to the extent of 15% was granted. That also, I think, your lordship, it is not that compelling.
Now, whether interest can be granted over future prospect. There is a apex court judgment, please.
Yes, your lordship.
What it says.
Right now, the status is that interest on future prospect can be granted.
Neeru's judgment.
No?
Neeru's judgment. There is a judgment, Neeru's judgment, Mala Neeru, I have that. And Mala, so for future prospect also it can be given. Mala 15% it is as part of Mala pronounced judgment, Mala clause, Mala that is 59.3. If age is between 50-60, then 15% future prospect. Along with the interest, my lord, that is also, my lord, in future prospect also interest can be added in total. That is also Neeru's judgment. Is the Neeru, that is, I have Oriental Insurance Company Limited.
What it says.
Lordship?
What it
Yes,
says.
my lord. Principle is that made, my lord, further the contention of taken is the higher rate of interest 9%. That is also, my lord, here it is given 6% only. 9% it can be given, my lord. It may be given, my lord. Further, the contention taken is the higher rate of interest 9%, insolence of which several precedents were placed before us. From the decision perused, what means is that in the 1980s, courts were awarding 12% interest, which stood reduced to 9% in 90s. Would advance to the 21st century and economic recession world over. The interest rates fell considerably. But even now, the rates offered by the national banks for long-term deposits are 7% or more. Considering overall circumstances, especially the long delay cost, we are of the opinion that 9% interest rate granted by the tribunal is perfectly in order of especially noticing the accident having occurred in the year 1995. Next, my lord. A very relevant issue agitated by the insurance company is the illegality in awarding interest for future prospect, which in any event in an amount received in advance, normally inuring in the benefit of claimants only in future. This is the only contention taken in the connected appeal bearing SLP number so and so. We find absolutely no reason to accept this argument. In SLPC number so and so, the multiplier applied looking at the lifespan of the deceased and the claimants is before the tribunal itself. The case was pending for 12 years and the only amount received by the claimant is rupees so and so. As though the amounts are awarded for future prospects, taking the multiplier of 13. In effect, the money is received only after the period for which the multiplier is adopted. Similar is the case SLPC number so and so, where the accident occurred in 2018. The multiplier applied is 17, and we are 7 years from the date of accident. We cannot but observe that there is nothing stopping the insurance company from settling the claim of the compensation on receipt of the intimation to the accident. In fact, it is due to the repudiation of or refusal of the consider the claim of the claimants are driven to the tribunal. That means, my lord, that judgment was also placed by my lord.
Thereafter, please read.
Yes, my lord. In the facts, it is due to the repudiation of or refusal to consider the claim that the claimants are driven to the tribunal when the matter is pending before the tribunal or in appeal before the higher forum. The claimants are deprived of the compensation for future prospect. If they are paid in time, it would be utilized by the claimants, and on failure, the loss of dependency would force the claimants to source their livelihood from there elsewhere. This is sought to be compensated at least minimally by award of interest, which obtainer them if her is nominal. Also, since only simple interest is awarded, if the amount were disbursed to the claimants on a rough calculation on intimation of the accident to the insurance company, subject to award of the tribunal, necessarily there would not have been any interest liability, at least to the extent of disbursement made. Hence, we reject the contention and direct the entire amount would be paid with interest at the rate of 9% from the date of filing of the claim till the date of disbursement, deducting only 50,000 granted as interim compensation in SLPC number so and so, and 6% interest in SLPC number so and so as awarded by the High Court, deduction to be made for the amounts already paid. That means 6% also that provision also deducted. And my lord, so far 9% was adopted, my lord. Along with this, said my lord, total interest, my lord. I'm placing all the judgment, my lord.
Your lordship, here 6% interest was granted, and interest is granted depending upon the economic condition of the country in that relevant time. So here the accident took place on 2011, your lordship. And also, if my learned friend wants to enhance the award, he ought to have filed a separate appeal or cross objection.
No, though not necessary. When there is honorable apex judgment, it is a continuous proceeding, my lord. Generally, held in appeal is in continuation of proceeding of original. No need to file any, my lord. That is also I have the judgment, my lord. It is valuable right of the appellant during this stage. All question of fact and law are open for the reconsideration. Therefore, appellant court required to address all the questions before it and decide the case by giving reasons. No need, my lord. At any time, my
Here
lord,
it
it
does
can.
not say that you don't have to file an appeal.
Heard Miss.
It is also, I am placing all the judgment, my lord. I have also marked here.
Okay.
I have marked here, paragraph marked, my lord.
Heard Mr. S. Datta, learned counsel for the appellant. Also heard Mr. H. Das, learned counsel for the respondent claimant. Hearing concluded, judgment reserved.
Your lordship, only one prayer. That statutory amount may be refunded.
Should I dismiss the appeal now?
Your lordship, it is a repeat case for that. Judgment is reserved, your lordship.
By following the, my
The
lord,
judgment is reserved.
Much better.
my lord, learned senior also placed that judgment in our honorable court judgment, my lord. That is also point out it her to enhance the same. In my other side, my lord, he is my lord, my learned friend, my lord, appeared and placed their judgment. Have given their judgment also, my lord. Kitab Jan Bibi also all everything judgment given. Obliged, my lord.
Much better.
Item 34.
जी सेवी बहुत है इसमें. Yes. Yes, 24. Who is for the other side?
Other side did not appear, lordship. Initially, when the IA was there, IA for delay condonation.
Your husband or wife?
I'm wife, lordship. It's an ex parte order. And I have just checked the record, what I understood, even the address also, it's written
But
as.
a divorce was granted.
Yes, lordship. And she was not aware. Right now also she is in his official quarter at Lumding. So all along she was there, quarter number, even the address, quarter number and nothing is mentioned in that, lordship. Whether lordship would like to hear on some other day.
Yes. Today, we
But
will give one chance.
Yes, lordship. One means it can be on next week, Thursday, lordship. On 13th.
Okay. Heard Miss D. Ghosh, the learned legal aid counsel appearing for the appellant. None has appeared for the respondent in spite of due service of notice of them on last occasion. However, one more chance is granted.
Lordship, we have given him enough chance, Lordship, and he knows about this proceeding. In the IA, one and learned advocate appeared also. Thereafter, he withdrawn the wakalanama.
This matter appeal is a no, continue. Good line to case.
Lordship, I'm appearing for respondent number 3 on behalf of RJ Das. So, my senior's health personal difficulties is for due to personal difficulties. So, to find the matter may be adjourned for the day.
Who is the appellant? Yes, Mr. Okay, heard Mr. A.J. Soikia, learned counsel for the appellant. Also heard Miss, what is your name?
CDB.
C. Devi, appearing for Mr. R.J. Das, learned counsel for the respondent number 7. Respondent number 3, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Also heard Miss D. Goswami, appearing for respondent number 3, respondent number 4, as well as Mr. K.U. Ahmed, appearing for respondent number 1 and 2 / claimants. The prayer for adjournment is not opposed by the other side, considering the grounds stated by the learned counsel. Hence, same is allowed. Let this matter be listed. When do you want?
2 3 weeks.
After 3 weeks. 10th of September.
Okay.
Take your lordship.
Who is the appellant?
The appellant, my lord, all because I being the wife, my lord, I have been suffering for a long time, my lord. And the land council was present, he has, the appellant has deliberately avoiding my lord in appearance, my lord. Only
Also, Mr. J. Hendrick, AP, Learned Government Council, appearing for respondent number. For the state respondent. State respondent. Learned Council for the appellant has submitted that the parties have reached an amicable settlement in this, already reached.
My lord, they have
They-
reached, my lord. We had actually filed an affidavit, but my apologies, my lord. There was a mistake on the part of my colleague, my lord, Mr. Espeko. My lord, there is a defect in the affidavit. I'll be withdrawing this and I'll be filing a fresh affidavit to the effect. Otherwise, the affidavit is also there.
Reached,
Copy is with my senior friends.
reached an amicable settlement and submits that they would be filing an affidavit without any defect on the next date fix and seek some time for the same. The prayer is allowed. Let this matter be listed when?
To my lord.
September 1st week. 2nd September.
Can it be on 3rd?
3rd September.
Yes.
Wait, please, your lordship. Your lordship, the contending counsel in this matter is unavailable due to personal difficulty. Your lord.
All three, 29, 30, 31.
Yes, your lordship.
Heard Mr.
A Dev
A. Dev,
on behalf of D. Rathi.
appearing for D. Rati. Also heard Mr. R.K. Dev Sharma, learned senior counsel, assisted by Miss N. Devi, learned counsel appearing for the appealing for the railways. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. The prayer is not opposed to by the other side, hence same is allowed. Let this matter be listed after 4 weeks on a date, no fixed date. Do you want fixed date? After
Your lordship, a fixed date if possible.
fixed date, tinta separate.
4 weeks.
Munun separate orders over there.
Convenient for the court, lordship, can it be on 3rd of September, lordship?
3rd of September. Okay, okay, 3rd of September.
Much obliged.